What's happening? What's happening? What up, Smarter? What up, Red? What up, Daniel? Hey, Purple. It is finally in. Lord have mercy, child. How long have we been waiting for this? I'm just downloading everything, y'all. Oh, let me tell this girl. She is right. Ooh. Mm. Hold on. I need number 2. Why number 2 ain't coming up? I need that part too. Yeah. Okay. Hold on, let me go back and see if I can get it again. Somebody else read it. I was a little lazy. Ooh, I want to know what it says, child. Cause you know I want to know what it says. Cause I want now we get to put it together to see do we have anything that can go on that habeas corpus, right? Go on that 2254, 55. That's what we want to know. Hey, Sonya. Is anybody else breaking it down? Let me know. Oh, Debo reading it. So I don't know why this thing will not let me download. Hold on. Probably somebody sent it to me. Shout out to the best information specialist in the world because I'm sitting up here like, they talking about it don't come in. I was like, I don't know. I don't think so. And I was turning over to look at the Tubi movie, another one, you know. I said, let me check. She's like, no, I heard it. I was like, okay, let me check. Hold on. We gonna see why this shit ain't letting me download. I need the dissenting. Accept and retrieve your charges. I do. Am I crazy? Documents. P-I-S-S-E-N-T. Am I crazy? Save. Okay, let's go and see if it's there. Okay, now it's there. Okay, so that's 170, 171, 172. Okay. Oh, well, what up, Mo? Girl. Get it on screen chat. Ooh. All right. Let me go to the facilities real quick and we would read. We shall read on it. We've been waiting for this for how long? Darn. One second. I knew I should have made my BLT. I should have made my BLT. Egyptian love. Egyptian love, baby. Let me get comfy. See what we got. More important, let's see if we got anything that we can take, we can use, y'all. Let's see if we got something we can use. Baby, I could have been reading this 2 or 3 hours ago if I would listen to my information specialist, honey. Another one. Uh-huh. So let me put this pillow this way. uh-huh. Where is where's the pad? There we go. I need to make it shit. Yeah, I'm sorry, I got okay. Oh damn, I don't want to do it that way because I can't see y'all. Okay. And this one, I need to make it bigger. Okay. Y'all ready? Okay. I'm coming. Give me 1 second. It's cold as hell now. It's like 63 degrees in here. Remember now, we listening for anything we can put on that habeas corpus, right? Okay. Child, I have a. Is this what is this, a majority? I don't know. And I have one that's a concurrent and dissenting. So I have two documents. This one is 85, 87 pages long. So here we go. Appeal from a judgment of the United States District Court for the Eastern District of New York, Donnelly, convicting defendant appellant, a recording artist and singer, of racketeering and Mann Act violations. Defendant appellant challenges his convictions on several grounds, including the sufficiency of the evidence and constitutionality of state laws underlying his federal convictions, and the impounding of certain jurors, and ineffective assistance of counsel during voir dire, and purported errors in the district court's evidentiary rulings and restitution orders. Affirmed, right? So they denied his appeal. Says Judge Sullivan concurs in part and dissent in part in a separate opinion. So that's what I just told y'all. So there I have a dissenting, okay, a concurrent dissenting in another part. And let me see. Okay. So, Lord, did they all write up? Oh my God, did they all feel strongly about this case? Did they all feel right apart? Oh my God. No, no, apparently they didn't. Hold on. Yeah, no, they didn't. Shit, I don't know. Let's read. Okay. Defendant appellant Robert Sylvester Kelly, a recording artist and singer, also known as R. Kelly, appeals from a final judgment entered in the United States District Court for the Eastern District of New York, Judge Donnelly, following a 6-week jury trial convicting him of racketeering in violation of the Racketeering Influence and Corrupt Organization Act, RICO, 18 U.S.C. Section 1962C, and transportation and coercion in violation of the Mann Act, 18 U.S.C. Sections 2421A, 2422A, 2422B, and 2423A. Remember when I told you, when you see the two conjoined S's like that, that means it's sections. And when you see one, it's section. Okay? It says, enabled by a constellation of managers, assistants, and other staff for over 25 years, Kelly exploited his fame to lure girls and young women into his grasp. Evidence at trial showed that he would isolate them from friends and family, control nearly every aspect of their lives, and abuse them verbally, physically, and sexually. Oh, Lord. On appeal, Kelly challenges primarily one, the sufficiency of the evidence supporting his racketeering and Mann Act convictions, including the underlying state and federal violations upon which they are predicated. Two, the constitutionality of certain of those underlying state laws. Three, the impounding of 4 jurors who were allegedly biased against him. Four, the district court's rulings on the admission of certain evidence at trial. And five, its order of restitution and the seizure of funds in his Bureau of Prisons, BOP, inmate account. We concluded that one, There was sufficient evidence to support each of Kelly's convictions, including for the state and federal violations underlying his Mann Act convictions, to the New York state law upon which some of the Mann Act violations were predicated was constitutional and applied to Kelly and Kelly's challenges to the California state law upon which some of the other Mann Act violations were predicated and untimely. Three, the evidence did not support Kelly's claim that the four jurors Kelly challenges were biased against him or that trial counsel was ineffective during voir. 4, the district court did not abuse its discretion in admitting certain evidence. And 5, the district court did not abuse its discretion in ordering restitution and the seizure of Kelly's BOP inmate account funds. Accordingly, the judgment of the district court is affirmed. Hold on a minute. I'm sorry, I got to tell you. I got to tell you. Okay. All right, background the facts. Following Kelly's initial indictment in June 2019, a federal grand jury returned a third superseding indictment, the operative indictment, on March 12, 2020, charging Kelly with 9 counts. Count 1 charged Kelly with racketeering in violation of 18 U.S.C. Section 1962C and set forth 14 racketeering acts as to 6 victims. Count 2 through 9 charged Kelly with violations of the Mann Act, 18 U.S.C. Sections 2421 through 2424. The racketeering acts in Count 1 and the underlying unlawful conduct in Counts 2 through 9 were predicated on various federal and state laws, including as relevant to this appeal. 1, 18 U.S.C. Section 1589A, forced labor. 2, California Health and Safety Code, CHSC, Section 120290, effective 1998, willful exposure of a communicable disease. 3, New York Penal Law, NYPL, Section 120.20, reckless endangerment. And 4, New York Public Health Law, NYPHL, Section 2307, knowing exposure of infectious venereal disease. The evidence presented at trial established the following facts. A. Kelly's Inner Circle. Kelly is an internationally recognized musician and performer. His career took off in the late 1980s. By 1990s, Kelly employed a network of associates consisting of managers and accountant, recording engineers, personal assistants, drivers, and runners. Kelly's Inner Circle worked not only to promote his music and professional brand, but also to enable him to exploit his fame and influence to sexually, physically, and verbally abuse a number of victims, many of whom were minors. Oh Lord, I'm sorry, y'all know when something get me, I get tied tongue, choked up, and my mouth don't do. Oh my gosh. Okay. All right. Let's see. Number 1, the members of Kelly's Inner Circle. Demetrius Smith, one of Kelly's first employees, met Kelly in 1984 when Kelly was a youngster performing at a high school talent show in Chicago. Kelly, APPXO, this reference 558.60. Smith worked as Kelly's personal assistant and tour manager from 1984 to approximately 1996, helping Kelly to secure his first record deal. At that time, Kelly employed Barry Hankerson as his business manager. Between 2003 and 2011, Tom Arnold also served as Kelly's studio and road manager. Darrell McDavid eventually took over for Hankerson. In 2004, Diana Copeland began working as Kelly's personal assistant and later became his executive assistant, spending about 15 years total working for Kelly. And when they get this detail like this, and they're usually, pretty detailed, they just want to make sure that this um, judgment stands up and just in case it goes further. Because remember, all of this is now part of the record. The record goes to wherever she kicked the, can down the street to. Okay. So they have to look at whatever reason that the appellate court gave for making its decision and to see if they agree or disagree or if they just want to, you know, make an independent, decision or whatever, right? But they will look at this. It says Kelly employed several runners, including Nicholas Williams, I ain't never heard that name before in my life, and Anthony Navarro, who completed miscellaneous errands for Kelly and his entourage. Later in his career, Kelly employed additional associates and personal assistants, including Cheryl Mack and two sisters, Suzette and Alicette Mayweather. In many respects, Kelly's staff had the responsibilities expected of individuals working for an internationally famous singer and recording artist. For instance, Navarro, a runner, worked at the recording studio in the basement of Kelly's home in the Chicago suburbs. Navarro's duties include setting up the studio for recording sessions, running errands, and assisting higher level staff. Arnold, Kelly's road manager, was responsible for maintaining the tour buses and coordinating travel to Kelly's shows. Number two, Kelly's staff facilitated the abuse of victims. Oh, Lord. There was, however, another aspect to the activities of Kelly's inner circle. Kelly's associates and employees made possible his decade long operation to recruit and exploit young girls and women by enabling, facilitating, and shielding Kelly's abusive behavior from view. First, at Kelly's direction, members of his entourage handed out Kelly's phone number on slips of paper to young girls Kelly saw at concerts and in public places. Once Kelly began communicating with the girl by phone, FaceTime, or text message, he or one of his associates would invite her to visit him, often at his home or studio. Sometimes Kelly sent an employee to pick up the girl. Upon arrival, a member of Kelly's staff was usually there to receive the guest, and Kelly would instruct his staff on where to take her. Kelly's employees were his eyes and ears in his studios, residences, and on the road, helping him to enforce the strict rules he had in place for his guests. They stood guard when Kelly confined his victims to a room or bus for hours or days on end as punishment for breaking his rules. When one victim, Anna, left Kelly's home without permission after an argument, Kelly confronted Copeland, who was then his personal assistant, about how she had let Anna leave. Beyond what was required to enforce his rules and communicate his demands and instructions, Kelly instructed his employees not to speak to his female guests. Kelly's employees knew that his abused girls, both verbally and physically. Wait a minute. Kelly employees knew that he abused girls both verbally and physically. For instance, Navarro overheard Kelly verbally abusing female guests, and Suzette Mayweather heard Kelly hit another victim, Jane, on at least one occasion. And although what's the name? J-Bo did not, you know, speak about all of this when she did her oral arguments or, was it in the briefs and stuff like that. Of course, all this was a part of the records. They reviewed everything, whatever. So this is why they're laying out the background and the facts that they use in order to make their decision. Okay. So this information I read is what they use to make their decision. Okay. All right. Kelly's employees knew or at the very least turned a blind eye to the fact that Kelly's female guests were often minors. Navarro recalled that the girls Kelly invited to the studio looked real young. Navarro was in his early 20s at the time, and the girls looked younger than he did, like mid-aged teenagers. Williams, another runner who was 19 years old when he worked for Kelly, thought the girls looked very young. Kelly's employees were responsible for arranging travel for the female guests to see Kelly, and in doing so, would review the girls' identification. When Arnold booked travel, he used the girls' names as they appeared on their ID and date of birth. Cheryl Mack booked travel for Jane when she was a minor. Jane, who admitted at trial that she had been concealing her true age from Kelly, provided her real identification and birth date to Mack. Suzette Mayweather later learned that Jane was 17 years old and, so far as the record shows, did not say anything. Juice, one of Kelly's live-in girlfriends, also learned that Jane was 17. So seem like they're basing a lot of blame. I'm sorry, putting a lot of blame also on the people around him. So they seem like they're trying to build this up like a and an organization of people that are doing both illegal and illegal acts, right? Which is the foundation of a RICO. So right now, it seems like that they're trying to make sure you know that this is a RICO. They're trying to explain to you that they are calling this a RICO. Now, this is profound. There's a reason why I'm pointing this out. All right, because I believe what the RICO portion of his sentence, what was 20 years, and they tried so hard, before the trial, during, and after, especially in her post conviction efforts, right, to undo the RICO. So right now, they are trying to let you know that they believe that this met all of the requirements and the elements to be considered as a RICO. This is why they are calling out all these people. Even though they weren't called out like this during the trial, the appeals court is calling out these people because they want to let you know that this is the foundation and their behavior was the formation of a RICO. Just in case if it goes anywhere else, they can see that they made that determination, based on this information. All right. Okay, members of Kelly's inner circle also knew that Kelly had sexually transmitted disease, STD. Dr. Chris McGrath was Kelly's primary care physician for approximately 25 years, beginning in 1994. As early as February of 1995, after Kelly had contracted gonorrhea, Dr. McGrath advised Kelly to disclose his STD status to partners and practice safe sex. Although Dr. McGrath could not remember the precise date that Kelly contracted herpes, Prescription records indicate that Dr. McGrath was treating Kelly for genital herpes by March 2007. Kelly had runners pick up his herpes medications from the pharmacy. When Anna got tested for STDs, the doctors sent the results directly to Copeland, Kelly's personal assistant. Juice, at Kelly's instruction, booked a doctor's appointment for another victim, Jane, when Jane began to experience herpes symptoms, and accompanied Jane to fill prescriptions for her treatment regimen. Wait a minute, did he call it Juice? Eh, okay. Employees faced consequences when they did not follow Kelly's rules. If Kelly determined that a staff member broke a rule, otherwise disobeyed him, he would withhold their pay as a fine. He required several members of his inner circle to write letters falsely incriminating themselves as blackmail material, and Kelly was not above threatening his staff to keep them in line. For example, after informing Mac of a lawsuit filed against him by a 17-year-old girl, Kelly told Mac that she had to pick a team, and that in these types of situations, people come up missing. Kelly and his staff abided by a strict set of rules with respect to his control over the young girls he invited to his home, studio, and tours. The rules ensured that he controlled virtually every detail of their lives while they were with him. Kelly required girls to wear baggy clothing around him. He made girls call him daddy. It says, it gives a reference. And it says Stephanie's testimony. And for women, let me just read it out. It says he made girls call him daddy. CEG government's appendix at 826 Stephanie's testimony, and forbade them from talking to other men. Girls needed permission to move around Kelly's residence or studio and even to use the bathroom. Likewise, girls were required to stay inside Kelly's van when traveling around Chicago. Kelly also required girls to write letters attesting to things they had never done, like stealing and lying, so that he could use the letters as blackmail and leverage. Kelly subjected his victims to humiliating, degrading, and often coerced sexual intercourse. For instance, he dictated how he wanted them to position their bodies during sex, forced one victim to perform oral sex on him with other people in the car, and demanded another victim to spread urine and feces all over her naked body while calling him daddy. Kelly also sought to punish the victims by demanding that they record humiliating videos. On one occasion, Kelly instructed Juice to procure a new iPad so that Jane could use it to film herself eating feces as a punishment. He also did not tell his victims that he had herpes and did not use a condom during sexual intercourse. Several of his victims contracted herpes after sexual contact with Kelly. B. The victims. The indictment referenced 6 victims. Because 5 are directly relevant to the appeal, we provide more detail on those individuals: Aaliyah, Stephanie, Jane, Geronda, and Faith. 1. Aaliyah. Excuse me. Kelly met Aaliyah in 1992 through Hankerson, his manager and Aaliyah's uncle, when she was at most 13 or 14 years old. Kelly and Aaliyah began working together on music and spent an increasing amount of time alone with each other. At some point, Smith asked Kelly if he was messing with Aaliyah, which Kelly denied. In the middle of a 1994 tour, before taking the stage to perform, Kelly told Smith that Aaliyah, in trouble, man, we need to get home. On the plane back to Chicago, Smith learned that Kelly was rushing home because Leah thought she was pregnant. Kelly told Smith that he and McDavid were planning for Kelly to marry Leah. Smith came up with an idea of procuring a false identification card for Leah, who was underage and could not legally marry. The group drove to a welfare office in Chicago where Smith bribed a city clerk with $500 to create a false identification card. The group created another identification card for Leah, which falsely stated that she worked at FedEx. Kelly and Aaliyah went to City Hall and obtained a marriage license using Aaliyah's false identification cards. A preacher married them at a hotel in a hasty ceremony. Stephanie. Stephanie met Kelly in 1998 when she was 16 years old and the flagship McDonald's in the downtown Chicago. A member of Kelly's entourage approached Stephanie, who was there on a double date with her boyfriend and another couple. The man asked Stephanie's age, and she responded truthfully that she was 16. The man handed Kelly's number on a slip of paper to Stephanie, gestured towards Kelly, who was looking at Stephanie from a distance, and told Stephanie that Kelly wanted her to call him. She threw the paper away because she did not intend to call Kelly. Stephanie encountered Kelly for a second time a year later. They began talking, and Kelly invited Stephanie to the studio, saying he would like to get to know her. Within a couple of weeks, Stephanie visited the studio where an employee escorted her to a waiting area. Kelly picked up Kelly Kelly picked Stephanie up and initiated sexual intercourse. Stephanie and Kelly continued to see each other 6 to 8 times per month for a period of approximately 6 months. They had sex every time they saw each other, and Kelly sometimes video recorded their sexual activity. Stephanie eventually did not want to see Kelly anymore because their sexual encounters made her feel used and humiliated and degraded. She did, however, attempt to convince Kelly to turn over or destroy the video recordings he had made. He never did. Excuse me. Number 3, Geronda. As a devoted fan and active member of Kelly's online fan club, Geronda met Kelly outside of federal court in Chicago, where Kelly was facing criminal charges in 2008 and where some fans had gathered. In May 2009, one of Kelly's associates, Bubba, Jermaine Maxey, invited Geronda and a friend from the online fan club to come to a party at Kelly's home. During the party, Geronda and Kelly exchanged numbers. At that time, Geronda was only 16 years old, though she lied and told Kelly she was 19. A couple of days later, Geronda returned to Kelly's house after he invited her via text message. The driver picked Geronda up from the train station. Upon her arrival, Kelly told Geronda, who had packed a two-piece swimsuit at his instruction, that he would meet her in his indoor pool room. At the pool, Kelly instructed Geronda to walk back and forth in front of him and remove one piece of her swimwear each time. Geronda did what she was told. Kelly, okay. I hate when they insert the references in here like that. Okay. Kelly, appendix at 115. Once she was naked, Kelly grabbed Geronda and began kissing her. He then picked her up and took her to his game room, where he performed oral sex on her. Geronda began to feel uncomfortable, which prompted her to tell him that she was 16 years old. Kelly told Geronda to tell everyone that she was 19 and to act 21. Geronda then performed oral sex on Kelly, and Kelly told Geronda that he was going to train her on how to please him sexually. Geronda and Kelly then had sex, and he did not use a condom or tell Geronda that he had any STDs that he had. Sometimes during their roughly 6 months relationship, Geronda contracted herpes. Kelly arranged for a doctor to see Geronda at his home. Y'all know I can't see. Let me turn this way. Turn to this monitor because I can't see. Okay. Kelly also introduced Geronda to Juice, a girlfriend who he'd been around since she was 15 years old. During their first interaction, Kelly brought Geronda onto his tour bus where Juice was inside and naked. Kelly told Geronda that Juice was going to train Geronda on how to sexually please him and that Geronda should follow Juice's lead. He then instructed both Juice and Geronda to perform oral sex on him. The last time Geronda was in Kelly's home, Geronda became angry at her for not acknowledging him. Wait a minute. The last time Geronda was in Kelly's home, Kelly became angry at her for not acknowledging him when he walked into a room. He slapped her and choked her until she lost consciousness. And when she got up, he spit on her and told her to put her head down in shame. Once she got up off the floor, Kelly instructed Geronda to perform oral sex on him, and she complied. For Jane. Jane first met Kelly during one of his concerts in April of 2015 when she was 17 years old. At some point during the show, a member of Kelly's entourage handed Jane a slip of paper with Kelly's phone number on it and instructed her not to tell anyone. Sometime later, Kelly contacted Jane over FaceTime and invited her to audition for him as an aspiring R&B singer. Jane, who was 17 at the time, lied and told Kelly she was 18. Kelly asked Jane to meet him at the Dolphin Hotel in Kissimmee, Florida, for her audition. Once inside the hotel room, Kelly told Jane that before she could audition, he needed to come. Jane told him that she was not there to please him and that she was there to audition. Undeterred, Kelly instructed Jane to remove her clothing, following Kelly's multiple requests to have sex with her. Jane ultimately allowed him to perform oral sex on her because she thought it would be better than having vaginal sex with Kelly. And he promised in return to allow her to audition. After ejaculating, Kelly permitted Jane to perform a musical audition, at which point he indicated that she had a lot of potential and offered to help Jane improve her singing. Jane proceeded to travel to Los Angeles to see Kelly perform on tour, and Kelly and Cheryl Mack arranged Jane's travel. When providing her information so that Mack could book her travel, Jane gave Mack her real birthday. Jane saw Kelly at his hotel in Los Angeles. He again told her that he wanted to teach her a few musical techniques, but that he needed to ejaculate again before doing anything. Kelly then performed oral sex on Jane in the Los Angeles hotel. And they keep referencing Cheryl Mack and all of that, whatever, and that she knew the birth date and all that type of stuff to just solidify that this was a RICO that had both illegal and legal operations going on, right? Just to make sure that they tied up with a bow that that this is a RICO. There's no questions about it, and that the elements, um, are presented here. So, um, where am I? So later, Kelly arranged for Jane to meet him in Stockton, California. Mac again booked Jane's travel using Jane's real birth date. In Stockton, Jane and Kelly had sexual intercourse for the first time. Kelly did not use a condom or tell Jane that he had herpes. In May 2015, Mac arranged for Jane to meet Kelly in San Diego, California, where the two had sexual intercourse again without the use of a condom and without Kelly's disclosing that he had herpes. Jane spent the summer after her junior year of high school in Chicago with Kelly. While spending time in Kelly's studio, Jane needed his or an assistant permission to leave her room. Jane traveled with Kelly while he was on tour that summer, and the two had sex almost every day. Kelly often recorded their sexual encounters on his iPad. When she was still 17, When she was still 17, Jane contracted herpes. She began experiencing pain during sexual intercourse, and her symptoms became so severe that she could not walk. Kelly directed Juice to book a doctor's appointment for Jane. When Jane told Kelly that she had contracted herpes, he became agitated and said that she could have gotten that from anyone. Jane responded that she had not Jane responded that she had only been intimate with him. At the end of that summer, before returning home to Florida, Jane told Kelly that she was 17 years old. Kelly and Jane were in Lincoln Park, Chicago, with Juice and one of Kelly's drivers when she told him. In response to the news, Kelly slapped Jane in the face with his open palm and walked away. Faith. Faith met Kelly when she was 19 years old after members of Kelly's staff invited her and her sister backstage during a March 2017 concert in San Antonio, Texas. Kelly gave Faith his phone number, and when she got home from the concert, she texted her name and a photo of herself to Kelly. Faith and Kelly thereafter started communicating via text, phone, and FaceTime. Kelly told Faith he loved her within a week of their first meeting. He invited Faith to come to see him on tour and gave her Diana Copeland's phone number for travel arrangements. In May of 2017, Faith made her first trip to New York to see Kelly. Kelly visited Faith's hotel room the morning after she arrived, and they had sexual intercourse, even though Faith told Kelly that she was not ready for sex. Kelly recorded the encounter on his iPad. Kelly did not disclose his herpes status to Faith or use a condom. Several months later, when Faith traveled with Kelly, to Dallas, he directed her to write something about her family that she didn't want anybody to know, which could be used to protect himself. Kelly also instructed Faith to send a text message that said, "Daddy, I want to be with you and the girls." All right, number 2. proceedings below. Before the trial, court prepared a written questionnaire. I'm sorry, y'all. My nose stopped it. 1 second. Let me unstop my nose. 1 second. Hey, Brielle. Thank you. Hold on. Let me blow my nose. All right. I am sorry about that. I had to open it up, child. Okay, number 2. Proceedings below. Before trial, the district court prepared a written questionnaire containing 108 questions for jury selection. Approximately 575 prospective jurors completed and returned the questionnaire. After reviewing the questionnaires, the parties agreed that 251 prospective jurors should be struck for cause, which means that there was a reason they struck them. Okay. Each party then challenged additional prospective jurors. Kelly's counsel challenged an additional 141 individuals. The government listed an additional 34. The district court excused all of these individuals before conducting voir dire. The remaining 145 underwent in-person voir dire, which began on August 9th, 2021, and took 2 days. The court impaneled 12 jurors and 6 alternates. Trial commenced on August 18, 2021. Over the course of 6-week trial, the government presented 45 witnesses and hundreds of exhibits, including written and videotaped evidence of Kelly's treatment of his alleged victims. After the government rested, the defense called 5 witnesses. Kelly did not testify. On September 27, 2021, the jury returned a verdict of guilty on all counts. The jury determined that the government proved all of its underlying racketeering acts in count 1 except racketeering act 3 and 4, kidnapping and Mann Act violations as to Sonia. After trial, Kelly moved for a judgment of acquittal and alternatively for a new trial under Federal Rules of Criminal Procedure 29 and 33. On June 29, 2022, the district court denied both motions. The district court sentenced Kelly on June 29, 2022 as follows: 360 months imprisonment on count 1, 10 years on each of counts 2, 6, and 8, and 20 years on and 20 years on each of counts 3, 4, 5, 7, and 9, all to run concurrently, followed by a 5-year term of supervised release. The court also imposed a $100,000 fine and a $40,000 assessment under the Justice for Trafficking Victims (JTVA) Act. 18 USC Section 3014, and a 900 special assessment. On August 4, 2022, the government directed the BOP to seize $27,824.24 in Kelly's inmate trust account. The government then moved for an order requiring the BOP to turn over the funds to the clerk of courts for deposit into an interest-bearing account. The government sought these funds either to satisfy Kelly's restitution judgment, which was yet to be imposed, or to satisfy the court-ordered fine, which had already been imposed. On September 9, 2022, the district court granted the motion. After briefing and a hearing, the district court imposed restitution in the amount of $379,649.90 as to two victims, Jane $300,668.18 and Stephanie $78,981.72. The appeal followed. Discussion. On appeal, Kelly challenges virtually every aspect of his trial and sentence, arguing that 1, there was insufficient evidence to support the Mann Act convictions, including the underlying violations of NYPL Section 120.20 and the Federal Forced Labor Statute 18 USC Section 1589A. 2, two state laws underlying the RICO and Mann Act violations are unconstitutional or were improperly applied. 3, the court impaneled 4 jurors who were biased against him, and trial counsel was ineffective for failing to seek their dismissal. 4, the district court improperly admitted evidence under the Federal Rules of Evidence 404B. And 5, the district court abused its discretion in A, ordering restitution as to Jane and Stephanie, and B, authorizing the seizure of funds from Kelly's bill. We address each issue in turn. I wish you get good now. Excuse me, y'all. 1, the sufficiency of evidence. Kelly's first contends that there was insufficient evidence to support his conviction under RICO Count 1 and the Mann Act Counts 2 through 9. He also challenges the sufficiency of the evidence of the underlying predicates of his RICO and Mann Act convictions, namely violations of NYPL Section 120.20, reckless endangerment, and the Federal Forced Labor Statute 18 USC Section 1589A. We conclude that the evidence was sufficient to all counts. Wow. What up, Diva? Okay, remember I was telling you about the standard of reviews? I told you that you want to make a sufficient enough argument, either by brief or oral, for them to apply a standard of review, right? And then because this was a direct appeal, they didn't have no choice. Anyway, they had to respond to it and apply one. So it says standard of review. We review preserved sufficiency. We review preserved sufficiency of the evidence claimed de novo. Okay, now remember I told y'all what de novo and all that stuff meant, right? So de novo means that they are reviewing as new, as if this case was never, any decisions had never been made in this case. It means as new, okay? United States versus Capers 20, F 4th, 105, 113, 2nd Circuit 2021, a defendant challenging the sufficiency of the evidence faces an uphill battle. Case law. It says the 2nd Circuit of 2013 and bears a heavy burden. More case law. Because a reviewing court must sustain the jury's verdict if viewing the evidence in light most favorable to the prosecution. Any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. Case law. So meaning that when they review this, they well with this particular hold on. Okay, because okay. So with what they're saying here, I guess somewhere between these the case laws um, that they have here, that they all we always want to protect the jury's verdict. That's the last thing we want to overturn, right? Okay, you always want to protect the jury's verdict, even when viewing the evidence in the light most favorable to the prosecution. You still want to protect the jury's verdict. So just in case it would have went the other way, okay. So that's pretty much what it means. Um, and they were saying that any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. So they're saying that anybody that reviewed this case, right, any juror, that they would have found the elements of the crime. Remember, because you have to convict based on the elements of the crime, the elements that they laid out during that indictment. Remember those elements? I beat it in y'all head in the beginning. Those elements, okay, that's in that indictment. That's what they needed to find present in the prosecution case in order to come up with a conviction. When you challenge for the insufficiency of the evidence, you are saying that no trier of fact could make a reasonable decision based on the evidence because the evidence is insufficient. That's why it's a sufficiency challenge. Okay? They're saying that that's not the case. They're saying that anybody, based on the evidence that they had, could make a decision. Um, so let me just be honest. All of this is just real bad. When they express it like this, you know, it's just real bad. They are actually making their decisions and they're actually providing case law that justifies their decision, which is not uncommon to do. But how direct they are with what they're saying, um, you know, I don't know how much hope. I don't know. I'm just being honest. Because I mean they're real thorough with it and all of this, and they're making sure you understand. Yeah, I mean it's a it's a it's a I want to call it a game because I did 14 years in the hood. It's a game behind it, but it's like they are securing their decision. They are double down on the judge's decisions that they challenged that Jabo challenged. They doubling down on the decision that the jury made to find him guilty. So that's what I'm saying. They're doubling down on what the victim witnesses said during the trial and all of that. And of course they are, they this is a standard you know judgment, right? And they this is what they do, but it's like they're writing it so that it's just saying they give they leave no doubt that he's guilty of whatever he was charged with. That's what I'm really trying to say. Okay. And because they believe that to the core, they're making sure that they cement it. Okay, that's what I'm talking about, the game in it. Because we always have a choice to use other words. We can still come to the same conclusion, but we can always use other words. They know that this problem is going to, go to another area, whatever. You understand what I'm saying? Go to the next one in line. So it says construing the evidence in the prosecution's favor means that we defer to the jury's assessment of the witness credibility and its assessment of the weight of the evidence. So that's kind of what I was trying to explain. Okay. The jury and the prosecution part I was talking about. More case law. It says a court may enter a judgment of acquittal only if the evidence that the defendant committed the crime alleged is not existent or so meager that no reasonable jury could find guilt beyond a reasonable doubt, which is what I just explained to you. They're saying that's not the case. Okay, B, the RICO conviction. Kelly argues that there was insufficient evidence to support his RICO conviction because the government failed to prove that, one, the enterprise had an illegal common purpose, and two, the enterprise was distinct from Kelly. We disagree. One, the applicable law. The RICO statute provides in pertinent part, it shall be unlawful for any person employed by or associated with any enterprise engaged in or the activities of which affect interstate and foreign commerce or foreign commerce to conduct or participate directly or indirectly in the conduct of such enterprises affairs through a pattern of racketeering activity or collection of unlawful debts. 18 U.S.C. Section 1962C. To prove a criminal RICO violation, the government must prove an enterprise and a pattern of racketeering activity. Case law. A RICO enterprise includes any union or a group of individuals associated in fact, although not a legal entity. 18 U.S.C. Section 1961-4. An association, in fact, enterprise is a group of persons associated together for a common purpose of engaging in a course of conduct. Case law. And has three basic features. One, a purpose. Two, relationships among those associated with the enterprise. And three, longevity sufficient to permit the associates to pursue the enterprise's purpose. Case law. In keeping with the principle that courts should liberally construe the RICO statute, the Supreme Court has noted that the term any ensures that the definition has a wide reach and the very concept of an association, in fact, is expansive. Oh, child. So, remember when I was reading earlier that they were laying out and letting you know that this was in fact a RICO? They are right there. It says the Supreme Court has noted they right there based on their interpretation. They interpreted what I told y'all all the time about certain federal laws are written broad, right? For this very reason. And you write a law broad so it can include a bunch of, behaviors as well as it can be interpreted liberally, right? So, where was I? Okay. It says, the Second Circuit in 2018, in line with this general approach, the Supreme Court has rejected attempts to graft onto the statute formal strictures that would tend to exclude amorphous or disorganized groups of individuals from being treated as RICO enterprises. In Turkey, the Supreme Court held that RICO covers both legitimate and illegitimate enterprises within its scope. It no more excludes criminal enterprises than it does legitimate ones. Bam. Didn't I tell you that that's what they was trying to do, to showing you the legal and illegal element? They want to make sure that they justify their decision here in calling this a true RICO. Okay, it said, in so holding, the Supreme Court emphasized RICO intentionally broad reach at 589 and noted that though the primary purpose of RICO is to cope with the infiltration of legitimate businesses, the statute could also be applied to reach exclusively illegitimate or criminal enterprises. I knew that's what they was doing. I knew it. For a RICO conviction to stand, there must be also a sufficient nexus between the enterprise and the racketeering activity. It says no RICO violation can be shown unless there is proof of the specified relationship between the racketeering act and the racketeering enterprise. Application. While Kelly's argument on appeal are not entirely clear. Well, damn. Okay, y'all remember, make sure that, and listen, we back in class. Make sure, I don't care if you're for or against, make sure you are listening for something that can be used at the next interval of this journey, okay? So it's either going to habeas corpus 2255 or it's going to Supreme Court, okay? Make sure you can try to listen for something. Diva, I know you can be twin engine brain with me, okay? You can do for and against. Y'all do for and against with me, okay? Work it out. Heard? They like, yeah, right. I don't want no part of that. Come on now, this is what we do. All right. While Kelly's arguments on appeal are not entirely clear, we nevertheless understand him to be making two arguments. One primarily legal and the other record-based. So I guess they're saying that the argument, I thought her argument on RICO was clear. I thought it was clear. Maybe, and I'm a transactional lawyer. I'm in the office. I don't do this. I don't want this smoke. I don't go to court. Transactional lawyers don't go to court. This is something else. Okay. I thought her argument was clear. I understood exactly what she was asking, what she was challenging when it came to the RICOs. But hey. Okay, Diva. Okay, she's taken to the Supreme Court. Okay. So it says, with respect to the first, Kelly asserts that members of an enterprise must have a fraudulent or illegal common purpose to be cognizable. I can never say that word. Cognizable. You ain't, baby. Come on. Cognizable. No, I can never say that word. Or maybe I can't say that word because I got big lip today. Cognizable. I think it's cognizable. Hold on. Cognizable. Okay. Cognizable. Enterprise under RICO. As for the second, Kelly contends that the government did not prove at trial the illegal purposes alleged in the indictment. And then they reference her oral. Okay, it says, to the extent Kelly argues that the law requires members of an association of fact enterprise to have a fraudulent or illegal common purpose, a substantial body of Supreme Court and Second Circuit precedent make clear that an association of fact enterprise need not have a fraudulent or illegal common purpose. In Turcotte, the Supreme Court held that RICO covers both legitimate and illegitimate enterprises. And in Boyle, the Supreme Court endorsed its prior holding in Turcotte, emphasizing that the definition of a RICO enterprise is obviously broad, as evidenced by the statute's use of the word any. Or Kelly asserts without citing authority that Turcotte assumed a RICO enterprise would have some criminal objective. He argues that Turcotte never suggested that an enterprise could be established by individuals engaging in a course of conduct with an entirely legal purpose that was unrelated to the alleged racketeering acts of one person in the enterprise. His argument lacks merit for two reasons. First, we do not read any part of Turcotte to suggest that a RICO enterprise must always have some criminal objective. Indeed, the question before the court in that case was the inverse, whether RICO would cover exclusively criminal enterprises. The court observed that it is obvious that Section 1962A and B address the infiltration by organized crime of legitimate businesses. Kelly's reading of Turcotte to say that a RICO enterprise will always have some criminal objective is clearly wrong. Yeah. I'm thinking. Okay. Second, by arguing that the government must prove an illegal course of conduct to prove a RICO enterprise, Kelly blurs the line between the RICO enterprise on one hand, which need not to be inherently criminal, and the pattern of racketeering activity on the other hand, which necessarily is the course of criminal activity by the enterprise. The Turcotte court expressly anticipated and rejected this line of blurring argument, explaining that in order to secure a conviction under RICO, the government must prove both the existence of an enterprise and the connected pattern of racketeering activity. The enterprise is an entity for present purposes of a group of persons associated together for a common purpose of engaging in a course of conduct. The pattern of racketeering activity is, on the other hand, a series of criminal acts as defined by the statute. The former is proved by evidence of an ongoing organization, formal or informal, and by the evidence that the various associates function as a continuing unit. That the latter is proved by evidence of the requisite number of acts of racketeering committed by the participants in the enterprise. ... The enterprise is not the pattern of racketeering activity. It is an entity separate and apart from the pattern of racketeering, the pattern of activity, in which it engages. Remember I told you Bonjean is clever with that pen? Yeah. So I don't want anybody to get it twisted that they're calling her inadequate or dumb or she doesn't know the law, this, that, and third, whatever. What she did was to defend her client, right? What she did was to exploit the portion of the law that's but that's either unclear or you can make unclear if you clever enough to do so. Okay, so I don't want no one to get it twisted as if she's an airhead or something like that. No, she made an argument, and again, I told you early on, I picked up that how she writes, she put pressure on the judge to do something, and 9 out of 10 times she wants them to interpret the law. In cases like this where the evidence is overwhelming and all this shit going on, your best bet, and you throw your Hail Mary, and when you try to get them to interpret the law, that means you have an independent person making a decision based on what they feel the law was trying to illustrate, what the law means, and what the rules and regulations are under the laws, and what's the substantive and the procedural mechanics of that particular law, right? So I just want to put that out there. So she did her job. Kelly's argument that the enterprise's purpose was unrelated to the racketeering acts is an argument about the nexus between the enterprise and the pattern of racketeering, but is not an issue we consider when determining whether or not a RICO enterprise exists in the first place. Okay. In support of his claim that individuals in a RICO enterprise must have a fraudulent or illegal common purpose, Kelly principally argues that we are bound by statements made in our decision in First Capital Asset Management, Inc. versus Satinwood, Inc. Specifically, he relies on our observation there that for an association of individuals to constitute an enterprise, the individuals must share a common purpose to engage in a particular fraudulent course of conduct and work together to achieve such purposes. Kelly's interpretation of Satinwood as setting a heightened standard for RICO enterprises overlooked the context of our discussion in that case. That quoted phrase was ancillary to a discussion regarding the nexus requirement between an enterprise and racketeering activity and was merely dicta. Moreover, the quoted language, if read as a holding, would contradict both Turcotte and United States versus Mazzei. There is no restriction upon the associations embraced by the definition of enterprise in Section 1961. On its face, the definition appears to include both legitimate and illegitimate enterprises with its scope. See also Cedric Kushner Promotions Ltd. The Supreme Court has held that RICO protects the public from those who would unlawfully use an enterprise, whether legitimate or illegitimate, as a vehicle through which unlawful activity is committed. In light of these cases and the language of the statute, an association of fact enterprise need not to have an explicitly fraudulent or illegal common purpose to be cognizable as an enterprise under RICO. We also reject Kelly's claim that there was no nexus between the enterprise R. Kelly brand and the pattern of racketeering activity. The requisite virtual nexus between the RICO enterprise and the predicate racketeering acts may be established by evidence that the defendant was enabled to commit the predicate offenses solely by virtue of its position in the enterprise or involvement in or control over the affairs of the enterprise. Case law. That is precisely the case here. The record is replete with evidence that Kelly was able to commit the predicate acts because he was the head of a close-knit group of associates and he controlled the affairs of the enterprise. For instance, members of Kelly's entourage participated directly in a predicate act when they devised a plan for Kelly to marry Aaliyah when she was underage. Fearing that Aaliyah was pregnant, Kelly told Smith that he needed to marry Aaliyah to protect himself. Kelly, okay, damn, I hate them damn references. Protect himself, and thereafter Smith and McDavid bribed a local clerk to obtain false identification for Aaliyah in violation of Illinois criminal bribery laws. Likewise, members of Kelly's entourage helped introduce him to underage girls. With respect to Kelly, a member of Kelly's entourage approached her at a McDonald's in 1998 and asked her age. Stephanie replied that she was 16. Even though Stephanie had disclosed that she was underage, Kelly's associate handed her a slip of paper with a phone number on it and told Stephanie that Kelly, who was watching the interaction from a distance, wanted to meet her. Stephanie ultimately met Kelly for the first time in 1999 when she was 17 years old. Kelly also directed his staff to facilitate his abuse of girls in violation of the Mann Act. Employees arranged for girls' transportation to locations around the country to engage in sex with Kelly, enforced Kelly's strict rules for the girls, and coordinated STD treatment for Kelly and his victims. As an example, Copeland received Jane's STD test results directly from the doctor, and runners picked up Kelly herpes medication. Juice also knew about Kelly's herpes and took girls to get tested for STDs. There is also overwhelming evidence that Kelly was further enabled to gain access to his victims because of his fame as a renowned singer and performer, a reputation his associates helped him maintain. Indeed, the evidence indicates that Kelly principally, come on, lips. I'm sorry, baby, they swole, baby. Relied on his reputation to entice young girls into his orbit. He dangled his influence and clout in the industry to reach his victims. A rational fact finder could therefore have found that the government proved the requisite nexus between the RICO enterprise and predicate racketeering acts. So, what they are doing right there, oh, my lips need a break for a minute. I'm sorry, y'all, let me rub them a little bit. What they're doing right there is just pretty much to make sure that the next body of judges to review this understand that they understand what a RICO is when they made the interpretation of the law in this case. Okay? And they are plugging in all the players and everything to show that indeed that there was a pattern of racketeering behavior going on, as well as there was a business that was, structured to maintain his career, his singing career. Okay. So that's when it seems like they're doing all this calling these people out. That's what they're doing. Hey, Carl. All right. It says Kelly's final challenge to his RICO conviction is that the enterprise was indistinct from him because it had no function unrelated to him. A defendant charged under RICO must be distinct from the enterprise such that the entity is not simply the same person referred to by a different name. So, where are we? Okay, so remember, the RICO person and the the enterprise itself needs to be separate. Hold on. Okay. Accordingly, we have rejected civil RICO claims where the defendant is a corporate entity and the enterprise is made up of the corporation's employees acting in the course of their employment. Riverwoods Chippewa Corp versus Marine Midland Bank, where employees of a corporation associated together to commit a pattern of predicate acts in the course of their employment and on the behalf of the corporation. The employees in association with the corporation do not form an enterprise distinct from the corporation. Kelly, however, is not a corporate entity. As we have explained, the plain language and the purpose of the RICO statute contemplate that a person violates the statute by conducting an enterprise through a pattern of criminality. And there's a long reference there. Kelly, a natural person, is distinct from many people at his employ who carried out his and his brand's affairs. In ordinary English, one speaks of employing, being employed by, or associating with others, not oneself. Moreover, the RICO provision applies when a corporate employee unlawfully conducts the affairs of the corporation of which he is the sole owner. We conclude that the need for two distinct entities is satisfied here. We therefore reject Kelly's sufficiency claim as to the RICO conviction. All right, Mann Act. Mann Act violations. Kelly argues that there was insufficient evidence that he transported Jane and Faith with the intent of exposing them to herpes in violation of the Mann Act. He contends that the illegal nature of the sexual activity was incidental to the trips and that he can be found to have violated the Mann Act only if he specifically intended to expose them to herpes. Kelly also argues that he did not coerce or entice Jane or Faith to travel to see him in violation of the Mann Act. We are not persuaded. Oh, dang. Now that's them saying that. That ain't me. Okay. 1. Applicable law. A. Section 2421. The Mann Act makes the Mann Act makes it illegal to knowingly transport any individual in interstate or foreign commerce with intent that such individual engage in any sexual activity for which any person can be charged with a criminal offense. 18 U.S.C. Section 2421A. To prove intent under Section 2421A, the government must establish that a dominant purpose of the travel was to engage the individual in the charged illegal activity. Section 2422A of the Act make it illegal to knowingly persuade, induce, entice, or coerce any individual to travel in interstate or foreign commerce to engage in any sexual activity for which any person can be charged with a criminal offense. 18 U.S.C. Section 2422A. The words attempt, persuade, induce, entice, or coerce, though not defined in the statute, are words of common usage that have plain and ordinary meanings. To determine whether the defendant had the requisite intent under Section 2422A, which imposes no requirement that an individual endeavor to transform or overcome the will of his intended victim, the jury need only to consider whether the defendant intended to induce, persuade, or entice the victim to travel to engage in illegal sexual contact with him, regardless of whether she expressed or felt reluctant, indifference, or, for that matter, enthusiasm at the prospect of doing so. Okay, what is that now? Induce, persuade. Oh, okay. So they're saying her willingness to go or her enthusiasm, whatever, is not a matter for, to be, that they need to make a decision on. Just that, just what the, the actual law says. Because remember, um, J-Bo, she would make arguments, not, she make arguments interpreting the okay, she make arguments kind of extending the meaning of the law, or of that particular law. And let me say it like that. She might say that, okay, well, in this case, like, whether or not Jane Doe was enthusiastic to go, or, like, led the charge to go, or whatever, that's neither here or there. The fact is that she went, and they're saying it was due to Mr. Kelly's coercion and inducement, enticement, all of that. Okay. So they're not, so to get away from it was Jane Doe who maybe, her and her mama created the the coercion or inducement, whatever, by being like, yeah, I'm happy to go, I'm not happy to go, or saying that he had to bribe them or whatever. They're saying that he didn't have to bribe them, and she didn't have to be enthusiastic to go. The fact that she went, and it was to, be with him, and he asked her to go and whatever, that satisfied that particular element of that law. Okay. I'm pretty sure they're gonna say that better. If I continue to read, let me see. What was that? Damn it! What was that? Okay. I wasn't done. Okay. Let me find a period and read, and I can continue. Cause I don't want to leave nothing out. When you leave something out, I don't want to disturb their thoughts. Okay, I don't want to interrupt their thoughts because it mess it all up. So okay, let me just start back right here. It said to determine whether the defendant had the requisite intent under Section 2422A, which imposes no requirement that an individual endeavor to transform or overcome the will of his intended victim, the jury need only to consider whether the defendant intended to induce, persuade, or entice the victim to travel to engage in illegal sexual conduct with him, regardless of whether she expressed or felt reluctant indifference or, for that matter, enthusiasm at the prospect of doing so. Okay, case law. And it said the Second Circuit of 2021 describing intent under Section 2422B, which uses language identical to that in Section 2422A. Application A. It says Section 2421. Kelly argues that any violation of the state laws which prohibit exposing sexual partners to venereal diseases were merely incidental to the women's travel. The district court's jury instruction, to which Kelly did not object, read, in order to establish this element, it is not necessary that the government prove that engaging in illegal sexual activity was the only purpose for crossing the state line. A person may have several different purposes or motives for such travel, and each may prompt in varying degrees the act of making the journey. The government must prove beyond a reasonable doubt, however, that a significant or motivating purpose of the travel across state lines was that the defendant would engage in illegal or sexual activity with the victim. In other words, that illegal activity can't have been merely incidental to the trip. Kelly intends that the statute requires proof that he specifically intended to expose the girls to herpes and that a general intent to engage in sexual activity chargeable as a crime would be insufficient. Kelly misreads the statute. Remember, we went over that. This is the part where we was going back and forth, where this is where Bunjean had picked up with the post-conviction motions in New York, and she put in that motion for a new trial and for an acquittal. And that's when we started talking about the text messages and stuff. Remember, we went over that. It says we start with the plain language of Section 2421A, which requires that Kelly knowingly transported Jane and Faith with the intent that they engage in sexual activity for which any person can be charged with the criminal offense. 18 U.S.C. Section 2421A, as the district court held, the government was required to prove that Kelly transported Jane and Faith with the intent of engaging in sexual activity with them, and that the intended sexual activity was illegal. Okay, so it was illegal because of the STD portion of it. And it says nothing in the statute requires a reading that Kelly was required to also possess the specific intent to expose the girls to the herpes. Even assuming he did not intend to infect them, he intended to have sex with them, and the intended sexual activity was illegal because he knew he had herpes, and he intended to engage in unprotected sex without disclosing his condition. So if I just read it, they'll tell you in much better language than I can. But they, just confirm what I was saying. We therefore hold that there was sufficient evidence here to show that Kelly transported Jane and Faith across state lines with the intent to have unprotected sex with them in violation of Section 2421. B. Section 2422. Kelly next argues that the government did not prove that he induced, persuaded, enticed, or coerced either Jane or Faith to travel for purposes of engaging in sexual activity violation of Section 2422A. Okay, and remember I told y'all, right? Because it was all of this about the parents and all this and stuff, whatever. And remember, I was letting y'all know that her and Faith, they pretty much had the same charges when it came to this portion of it, the STD. And it was, we was having arguments about the text message, the coercion part, and all that type of stuff. As you see it here, the appeal, the appeals court. I'm sorry, mouth and the head hurt. The appeals court have put these two females together, referencing them together when they're explaining this portion of it about the coercion, the enticement, inducement, the herpes, and all of that, because it has nothing to do with them damn text messages. It's about the inducement, enticement, coercion, and all that cross state lines and contracting the herpes. Okay, that's what it's about. That's why you see these two females are lumped together, even when you see one was supposed to be a minor and one was an adult. Okay, I'm not saying that they're not going to elaborate on the fact that she was, if one of them was a minor. I don't know if they're going to do that or not. But what I'm saying is, in that when we was having all those goddamn arguments about the text man, all this and that, and I kept saying no, it's about the coercion, enticement, inducement, whatever. I said it so much I had it down pat, and them herpes. That is what that particular those elements were about. That is what the government had to prove, and the appeals court is saying that they satisfied that. All right. Says Kelly next argues that the government did not prove that he induced, persuaded, enticed, or coerced either Jane or Faith to travel for purposes engaging in sexual activity in violation of Section 2422A. He argues that it was Jane and her mother. Oh boy, that's going to get good now. And her mother who tricked him into spending time with Jane without disclosing that she was underage. Similarly, Kelly argues that because Faith was of age, she could not have been coerced or enticed to travel. Here we go. These arguments take the focus away from Kelly and the direct focus to the intent of Jane and Faith. The victim's intent, however, is not relevant to the inquiry. Come on. Y'all, I'm learning all the ghetto stuff. I'm clocking it back in with the fingers. I'm clocking it. Meaning what I've been trying to tell you. They could have said, come on, cross the line. I'm naked with a bow on it. Whatever. They had nothing to do with what the government had to prove. That was some goddamn elements. And it's kind of hard to do, to do what we was doing over here without having a file, without having what they had in front of them. But I said we did a goddamn good job putting it together. And again, I know we was wrong at some point. I just can't remember when they ever came back and said that we was wrong. I'm just trying to figure that out. When the courts and all the people, the lawyers and the judges and shit, like the people that was in there with the paperwork, with the files. Yes, I'm popping my shit and y'all shit too, because I'm on one up here. That said we was wrong. We weren't. They don't. So what I'm trying to say is, them text messages now and them text messages later ain't gonna mean a goddamn thing, because their behavior can be found in those text messages. That's one reason why the text messages would never be relevant. Two is because of the age and all that other shit, right? Well, let's deal with that. Okay, let's keep going. Told you this part was going to be good. Indeed, we have explicitly rejected an approach to Section 2422 that moves the locus of the offense conduct from the intent and the actions of the would-be persuader to the effect of his words and deeds on his would-be victim. Oh, I'm gonna keep reading because they done broke it down. Okay, and I'm not saying I'm for nobody. Well, y'all know I ain't whatever. I'm just for. We was right. We was right. Shit. With a proper focus on Kelly's intent in his interactions with Jane and Faith, we conclude that there was sufficient evidence for a jury to find that he coerced and enticed them both to travel to engage in sexual activity for which Kelly could be charged with a criminal offense. Kelly argues that he merely invited Jane to see him and that Jane's mother orchestrated their relationship. Here we go. Even if Ooh, come on. Even if it is true that Jane's mother helped Jane craft messages and plan her interaction with Kelly, that does not alter the inferences a rational jury could make about Kelly's mindset and intent. A rational jury could and did conclude from this evidence that Kelly coerced and enticed Jane to have sex with him using promises of free travel to see him perform and tutelage from him in her own career, and that this conduct accordingly violated Section 2422A. They keep bringing it back to 2422A, which is where the elements are, which is what I was trying to tell y'all. Okay? They don't give a damn about none of that. They only dealing with what's enumerated and unenumerated. But right here, it's enumerated because it is written. And I told you that this shit goes by FRCP and FRE, right? What they are referencing, FRCP and FRE. Right now, we doing a little bit of both. Procedural and substantive law. This is what we're doing. Oh, this is what they're doing. I'm just reading it. So again, y'all keep thinking because we got to find out what is his pathways forward. Now, again, I don't like limiting my chances, right? I said that there should have been a pardon application in there to Biden, anybody else, but that's just my opinion. You keep on and just you keep working it. And again, I know she's the best person for the job, but I don't know what the fuck is going on. But when you're talking about habeas corpus, this is going back to Judge Ann Donnelly. Or if you can work it out, it's going to the Supreme Court. If so, you know. Where we at? Okay, the same is true for Faith. Even though Kelly argues that Faith, unlike Jane, was a fully consenting adult woman. The government presented evidence at trial that Kelly told Faith he loved her and encouraged her to visit him while he was on tour. He sent Faith Copeland's number so that Copeland could arrange for Faith's travel. He brought up the topic of her visiting him and encouraged Faith to make plans to do so. While these actions were not in themselves illegal, there was ample evidence in the record that Kelly did these things so that he could have sex with Faith in his usual manner, without disclosing his herpes diagnosis and without using condom, in violation of state law. Accordingly, there was sufficient evidence from which a jury could find inducement under Section 2422A, Ninth Circuit 2002. It is not sufficient, it is not significant, that the victims had pre-existing wishes to travel, especially considering that they never acted upon those desires until the defendant made it attainable. D. New York Penal Laws, Section 120.20. Kelly also challenges the sufficiency of the evidence supporting his violation of NYPL Section 120.20, which is the predicate crime upon which two racketeering acts and several Mann Act convictions are based. Kelly asserts that the government failed to prove a violation of Section 120.20 because unprotected sex with a person who carries the herpes virus does not establish a substantial risk of physical injury. We disagree and conclude that there was sufficient evidence from which a rational jury could find that Kelly violated Section 120.20 based on his sexual conduct with Faith. 1. Applicable law. Under New York law, a person is guilty of second-degree reckless endangerment, a Class A misdemeanor, when he recklessly engages in conduct which creates a substantial risk of serious physical injury to another person. New York Penal Law, Section 120.20. Serious physical injury is an injury that causes protracted loss or impairment of the function of any bodily organ. 2. Application. As the jury heard from experts at trial, herpes is a transmissible, sorry, my lips is slipping, baby, virus that is both highly contagious and at times difficult to detect. The herpes virus stays in a person's central nervous system forever, and it can it can reactivate to cause outbreaks of blisters, ulcers, what is pulses? What is pulses? Baby, I don't do medical. And viscilis, I guess, which can cause numbness and severe pain. We need a medical information specialist. I've been trying to get one. Can we get one of those? Or an insurance one? I ain't do this part of insurance, but we need one of those too. And let's see. Okay. On occasion, but rarely, it can lead to brain and central nervous system complications. Jane's herpes symptoms were so severe at one point that she could not walk. Kelly did not disclose his herpes diagnosis to his sexual partners, including his victims, nor did he use condoms during sex despite Dr. McGrath's admonitions to use protection because of his diagnosis. Kelly also had a habit of requesting new Valtrex prescriptions even when Dr. McGrath prescribed him enough medication to last months at a time. Based on this evidence, a jury was free to conclude that Kelly engaged in unprotected sex with his victims without disclosing his herpes infection and was not regularly managing his with medication. A jury could find that in doing so, Kelly created a substantial risk of serious physical injury to the victims by exposing them, including Faith, to genital herpes. Kelly argues that because there is no evidence that Faith contracted genital herpes, there is insufficient evidence that he violated Section 120.20. This argument is meritless. You mean she ain't got no evidence that she contracted herpes? What kind of shit is that? She got no evidence. Huh? Wait a minute now, because I remember us talking loosely about that. But it's the fact that she was exposed to it. What you mean they ain't got no evidence? Let me keep reading. That ain't my business. Okay. Section 120.20 criminalizes exposing another person to substantial risk or serious physical injury. Under the plain language of the statute, it is not necessary that a person be, in fact, injured. The law merely criminalizes the creation of a substantial risk of injury. Y'all know I get excited. And my lips are swollen. Says since the occurrence of an injury is immaterial, the fact that the defendants could not have foreseen the manner in which this injury occurred does not negate their liability under the statute. There was sufficient evidence from which the jury could have concluded that Kelly recklessly subjected Faith to a substantial risk of by having unprotected sex with her and not telling her about his herpes diagnosis. Forced labor. Kelly was convicted of violations of the Mann Act in connection with Geronda and Faith, predicated on his violation of the federal forced labor statute, 18 U.S.C. Section 1589A. Thank you, Brielle. As to both Geronda and Faith, Kelly argues that he merely engaged in consensual, isolated sex acts with each woman and that no rational juror could conclude that Kelly obtained their labor or services through force in violation of the federal forced labor statute. His arguments lack merit considering the evidence adduced at trial. The applicable law. The federal statute prohibiting forced labor, 18 U.S.C. Section 1589A, requires the government to prove 1. The defendant obtained the labor or services of another person. 2. The defendant did so, A, through threats of serious harm to or physical restraint against that person or any other person, or B, through a scheme, plan, or pattern intended to cause the person to believe that the non-performance would result in serious harm to or physical restraint against that person or any other person, and 3, that the defendant acted knowingly. And you have some case law there. Labor is the expenditure of physical or mental effort, especially when fatiguing, difficult, or compulsory. Okay, and service is the performance of work commanded or paid for by another. Okay, there's some case law. Besides showing that a defendant obtained the labor or services of another person, the government must also establish a causal link between the labor and services of the serious harm. Serious harm is any harm, whether physical or non-physical, including psychological, financial, or reputational harm, that is sufficiently serious under all the surrounding circumstances to compel a reasonable person of the same background and in the same circumstances to perform or to continue performing labor or services in order to avoid incurring that harm. 18 U.S.C. Section 1589C2. Let me get some water real quick. All right, application. The evidence presented at trial was sufficient for a jury to conclude that Kelly violated the forced labor statute as to Geronda and Faith. Kelly asked us to focus on what he characterizes as the isolated nature of the sex acts themselves, arguing that if we allow his convictions predicated on violations of the forced labor statute to stand, we would be federalizing state law. We understand this concern as a general matter, but we need not to address the reach of the forced labor statute as the margins, whether the statute would cover a single instance of rape, because this is not a marginal case. As we have described at length in this opinion, there was extensive evidence showing how Kelly ensnared young girls and women into his orbit, endeavored to control their lives, and secured their compliance with his personal and sexual demands through verbal and physical abuse, threats of blackmail, and humiliation. A jury was permitted to infer from this evidence that Kelly had in place a scheme, plan, or pattern intended to cause the girls to believe that they would be harmed if they did not comply with his sexual demands. Case law. Finding sufficient evidence to support conviction under Section 1589, where there was evidence that the defendant witnessed his wife humiliate live and domestic servants, force servants into humiliating and painful punishment, and physically abuse the servants. That's as it relates to the case law. There is ample evidence to support the jury's conclusion that Kelly obtained the sexual labor of Geronda and Faith during the relevant time periods in between May 2009 and January 2010 for Geronda, on January 13, 2018 for Faith, through threats of serious harm or physical restraint. Kelly exerted tremendous psychological and physical control over Geronda. For instance, he required her to write a letter falsely admitting to stealing $100,000 of jewelry and to lying about contracting genital herpes from Kelly. He hit her when she disagreed with him. He told her that Juice was going to train her how to sexually please him. He played her a video of them having sex so that he could critique it. On one occasion, he slapped her and choked her until she lost consciousness after Geronda came to Kelly and instructed her to perform oral sex on him. Faith was also subject to psychological control by Kelly. In Los Angeles, Kelly kept Faith waiting in a room for hours without food or water because she did not greet him properly when he first saw her. When Kelly returned to where Faith was waiting, he instructed her to take her clothes off and walk back and forth. Faith said she didn't want to have sex with him. They went to another smaller room where there was a gun on the ottoman. Kelly then grabbed Faith's neck and guided her into performing oral sex on him as the gun was next to him. Faith testified that she did so because she felt intimidated and that she was under his rules because he had a weapon. Accordingly, there was sufficient evidence for a jury to find that Kelly find Kelly guilty of forced labor as to pay. Okay. Constitutionality. Okay. Constitutionality of the state's statutes. Kelly challenges two state laws convictions that underlie the RICO and Mann Act convictions, arguing inter alia that the laws are unconstitutionally vague. Specifically, he claims that one, the government failed to prove that Kelly was infected within the meaning of NYPHL Section 2307. 2, Section 2307 is unconstitutionally vague. 3, the government improperly indicted Kelly under the 1998 version of CHSC Section 120290. And 4, Section 120290 is also unconstitutionally vague. We disagree with his first two arguments and find that the third and fourth arguments are untimely. And y'all know what untimely means, right? That they pretty much didn't make the arguments in time. And I don't know if this was when they were arguing. Oh, yeah, this was when they was arguing whether it should have been a rule, I think 12. Whether it should be a pretrial motion. Okay, when they were talking about the the um, the version that was used or the language in there, what have you, and the time to have made that argument would have been pretrial, but it wasn't, and so forth. I believe that this is what they are talking about. So I don't know if they'll get into it to confirm it, but let's go. It says the due process clause of the the 14th Amendment requires that each criminal statute, one, give the person of ordinary intelligence a reasonable opportunity to know what is prohibited, and two, provide explicit standards for those who apply the statute. Case law. The Second Circuit in 2010, it says a statute prevents vagueness concerns if it does not define the criminal offense with sufficient definiteness, that ordinary people can understand what conduct is prohibited, and in a manner that does not encourage arbitrary and discriminatory enforcement. Case law. Moreover, when, as here, the interpretation of a statute does not implicate First Amendment rights, it is assessed for vagueness only as applied, i.e., in light of the specific facts of the case at hand and not with regard to the statute's facial validity. Case law. More case law. Because a plaintiff who engages in some conduct that is clearly proscribed cannot complain of the vagueness of the law as applied to the conduct of others, we will uphold a statute against an as applied challenge if the particular enforcement at issue is consistent with the core concerns underlying the statute. Case law. More case law. Thus, a defendant who brings a facial challenge to a criminal statute that does not touch on First Amendment rights will fail unless he can establish that no set of circumstances exist under which the law would be valid. Case law. What are you talking about? Let me see. What are you talking about First Amendment rights right there? I'm going to go back and see that. Check it out. It says standard of review. Where a vagueness challenge is not raised before the district court, we will review for plain error on appeal. We typically do not find plain error where the operative language question is unsettled, including where there is no binding precedent from the Supreme Court or this court. Okay. Okay, so when they say they're going to review for plain error, that means that they're going to they're saying I guess something wasn't raised before the district court. I don't know if that's what I was talking about, but they said that they review it for plain error on appeal. So that means that they're going to allow the district court more deference, right? They're going to take in consideration their opinion of this particular matter before um, you know before versus reviewing it de novo, meaning reviewing it not giving the district court that much deference, right? Not relying too much on what the actual determination of this matter came out to be. Okay, it says we typically do not find plain error where the operative legal question is unsettled, including where there is no binding precedent from the Supreme Court or this court. Okay, so this matter is wide open. Let's see. New York Public Health Law, Section 2307. Kelly's challenge to NYPHL, Section 2307, need not detain us long. Oh boy. They rude as hell. Them New Yorkers, baby. God damn. He contends that the government presented no evidence at trial demonstrating that he was infected with a venereal disease during his sexual interactions with Faith. Because Kelly's conduct falls within the core of the conduct prohibited by Section 2307, and a person of ordinary intelligence in his position would understand what infected means under that section, we reject his vagueness challenge. Oh, Lord. Mm. Section 2307 provides that any person who, knowing himself or herself to be infected with an infectious venereal disease, has sexual intercourse with another shall be guilty of a misdemeanor. New York Public Health Law, Section 2307. Kelly argues that he was not infected within the meaning of Section 2307 because infected must be interpreted to mean active infection to avoid constitutional concerns. Because he was not experiencing an active herpes outbreak when he had sex with Faith, Kelly claims that the government did not prove a violation of the statute. He also argues that the provision is unconstitutionally vague because it effectively prohibits individuals with venereal diseases from having consensual sex. Okay, J-Bo, I don't remember you doing all of that or whatever. Okay, that was a good swing at him. Our analysis began at it must with the plain text. And you have case law. Absent a definition in the statute, we must give infected its ordinary meaning when interpreting Section 2307. It is axiomatic that the plain meaning of a statute controls its interpretation and that judicial review must end at the statute's unambiguous terms. Okay, remember I tell you, they interpret it where the law is ambiguous, it ain't quite clear, it maybe contradicts itself or whatever. That's when a lot of interpretation is supposed to be done. But J-Bo wants you to interpret plain language, okay? Which is a smart thing to do because again, you are making a judge become more human and start thinking, and maybe seeing where the law is unconstitutional or something, and they can make decisions that can, rule in his favor. They can make changes to law, that type of stuff, right? So she's doing right. They sound harsh, okay, but she did the right thing. Okay, a person is infected when he or she contains or carries a source of infection. Well, that's pretty plain. Let me see. It says the 12th edition 2024 defining infect as to contaminate. Kelly's contention that a person is infected only, wait a minute, only when he or she is expecting an active outbreak of some disease or virus strains credulity. To limit the definition of infected to active outbreaks would contravene the plain language of infected and its commonly understood definition. And they put the Merriam-Webster in here. They smart. They got some smart mouths up there in New York, honey. And it says July 12, 2024. Thank you, Purple Purple. To be contaminated with an infective agent, such as bacterium or or virus, it would also contravene the statute's purpose, which is designed to protect sexual partners of people who know that they are infected with a virus but might not be obviously infected. The evidence at trial established that genital herpes is an STD spread by engaging in sexual acts with an infected person, regardless of whether the person is experiencing an outbreak. Once transmitted, the virus stays in an infected person's nervous system forever, and though it can lay dormant for periods of time, the person can still infect others with the virus. Kelly also argues that he was not on notice that he was infected, but this argument is meritless considering the evidence at trial that established that Kelly was diagnosed with herpes and was aware of his diagnosis. The remainder of Kelly's vagueness challenges appears to be a facial challenge, which we must reject because Section 2307 does not implicate First Amendment rights, and Kelly has not come close to meeting his burden of showing that there is no constitutional application of the statute. Now, I had to go back and see what the First Amendment right portion about this um, was about. But remember when I told y'all that First Amendment, those First Amendment arguments about this, about that, and they sticking it here and sticking it there, where sometimes it doesn't seem to belong. Then I tell you that it was making its round when it comes to the law. I don't even know what the First Amendment got to do with this case. I forgot if it was there somewhere. It says Kelly purports to invoke the due process rights of the millions of individuals who have herpes against whom enforcement of the statute may be unconstitutional. But because we treat this as an a, as applied challenge, Kelly's invocation of the rights of others whose conduct falls at the outer bounds of Section 2307 fails. It says Second Circuit 2006 explaining that federal courts, as a general rule, do not allow litigants to assert the legal rights and interests of third parties. Kelly's conduct falls comfortably within Section 2307's reach. He knew he had a highly contagious, incurable STD, and he knowingly had unprotected sex with multiple women, including Faith, without disclosing his condition, thus exposing them to the virus without their knowledge. Kelly's vagueness challenge fails. And they move on to California. California Health and Safety Code. Let me see if I can make this bigger because I am struggling seeing this chart. I apologize. I can't see. My ass can't see chat. I got a whole new different setup. I told you. When people say, oh, you ain't using this, you ain't using this, people say this up, people say this up. So this ain't my usual setup. So I apologize. My ass can't see. I got a lot going on. Okay. Let's see. Is this better? All right. California Health and Safety Code Section 120290. As to CHSC Section 120290, Kelly argues he was improperly charged under a now repealed version of the statute and that the repealed version is unconstitutionally vague because this objection was not properly raised in the district court. It was forfeited and we do not reach its merits. So I think this is what they were talking about, what I was explaining to y'all earlier, that wasn't raised in time. What I think it was supposed to be a pretrial motion. It says applicable law. The version of CHSC section 120290 in effect at the time of the conduct charged in the indictment between April and May 2015 provided any person afflicted with any contagious, infectious, or communicable disease who willfully exposes himself or herself to another person, and any person who willfully exposes another person afflicted with the disease to someone else is guilty of a misdemeanor. California Health and Safety Code Section 120290 in 1998. Application. The government argues that, that Kelly's claim that he was improperly charged under the 1998 version of Section 120290 is untimely under Federal Rules of Criminal Procedure 12C3 and is also meritless. So I was right, it was Rule 12. We agree as to timelessness. Federal Rules of Criminal Procedure, also known as FRCP 12B3CB, provides that a defect in the indictment must be raised by pretrial motion if the basis for the motion is then reasonably available and the motion can be determined without a trial on the merits. Okay, so remember I was explaining that this is when I believe that the motion with regards to one of these diseases should have been raised at pretrial. This is where they're explaining my hypotheses. Okay. Here, the indictment made clear that the government was charging Kelly under the 1998 version of CHSC and Section 120290, the version in effect at the time he engaged in the charged conduct. But Kelly did not raise an objection to the use of the 1998 version until several weeks after the trial had commenced. Indeed, trial commenced on August 18, 2021, and Kelly did not raise the issue until September 18, 2021 in a letter to the court. His challenge was therefore untimely under Rule 12b3b. And you have some case law. If a motion falling within Rule 12b3 is not made before trial or before such pretrial deadline as may be set by the court for such motions, it is untimely. Moreover, Kelly did not explicitly object to the 1998 version of the statute used in the indictment. Instead, he first raised the issue while trial was underway, when he submitted a letter requesting amendments to the proposed jury instructions. In his letter, he observed that CHSC section 120290's text was different from the text provided of the 1998 version in the in the jury instruction, but proposed no alternative language for use in the instruction. The district court did not explicitly rule on the request, but effectively denied it by using the 1998 version of the CHSC section 120290 in the issue jury instructions. Before trial, Kelly made no arguments with respect to an improper charge or a defect in the indictment, and he did not ask the court to dismiss the charge. He also did not argue before the trial that the 1998 version of the statute was unconstitutionally vague. And we have some case law, and it says the Second Circuit of 2000, finding that because the defendant failed to identify any terms in the indictment that were too vague or general, in his pretrial motion to dismiss his indictment as vague, his motion was untimely and his objection was forfeited. But see in Federal Rules of Criminal Procedure 12C3, Advisory Committee's notes to the 2014 amendment, new paragraph C3 governs the review of untimely claims previously addressed in Rule 12E, which provided that a party waives a defense not raised within time set under Rule 12C. 12C3 retains the existing standard for untimely claims. The party seeking relief must show good cause for failure to raise a claim by the deadline, a flexible standard that requires consideration of all interests in a particular case. Because Kelly did not argue, much less demonstrate good cause for failing to raise a pretrial challenge to his indictment, his argument, in addition to being untimely, was forfeited. In light of this conclusion, we do not address we do not address the related merits argument. Okay. One second, y'all. Let me get something to drink. 1 second. Y'all put in chat what y'all think so far, and I can look at them when I come back. This is, it is what it is. Okay, I'm here. Let me see. I wonder if he feels right now knowing that he's not. Oh, Lord. Leave it ain't the question. It ain't the, what I. Um, yeah, this it's kind of brutal. Yeah, I want me a BLT so goddamn bad. But when I tell you, I ain't even about this damn brownie. I ain't even and I can literally take y'all with me. But that damn oven cooks so darn fast. Literally, I preset the dang on oven. Put that bacon in there in about 5 minutes. The bacon is brown and I mean it's like crispy. I'm like, what is going on? So I don't know if that's a sign that I need another stove or what. But so remember I could put food in there and take all day and come talk to y'all and go check on it and all of that. Them BLTs I have to watch over and I cook. And I'm not listen. I done got so good, y'all. Y'all got to give me my props. Like I would have been ordered them $20 BLTs. I'm like that's crazy. When I can go get a gang of bacon like I did, some lettuce, some bread, stuff I don't typically eat, but when I get on something, I'm stuck on it. And bye. Yeah, that Rule 12, that's his counsel thing. That is his lawyer thing. That falls on that lawyer. And because it's dealing with the herpes, maybe if the argument was made on time, maybe that could have made a difference. You understand what I'm saying? Because if he is right that the other version should have been used instead of that version or whatever, then you understand what I'm saying? It can make a difference because he got a lot of he got his sentence was due to them a good portion of it due to them damn herpes, right? hmm And wait a minute, and that would have affected. We talking about California, right? So who all was over there in California? hmm So that does fall on lawyers, right? I ain't gonna back them, but it falls on there. I don't know. Right, Diva. Mm-hmm. Falls on the lawyers. Well, I'm gonna bite. I'm gonna. Maybe I be on some real fat girl stuff. mm I made the richest brownies, child, and then I put peanut butter inside the brownies, and then I put just on mine. I put peanut butter on top of it, like a coating. Oh, girl. And I got some boy. I went and grabbed some boy peanut. They will be like thawed out by the time I get off him. Baby, Jimmy Carter will be proud of me. Not fat girl. Fighting with these big old swollen lips with this peanut butter. So give me a minute. Trying to get it off. Mo, I found on my side where I tell you what happened. I found a big old knot on the side of my dang on leg. I got one on my head. That thing on my shoulder is clearing up. I got a big old knot on my thigh. Okay. Yep, that's my glove. So I just don't like stuff all in my hand. Yep. Oh, and people have licked their fingers. Oh my god. Oh, they get to that. Especially when they be eating them chips or something. And they be, oh, girl, I be like, oh, Okay. I know I'm hard headed. No, I'm not. I'm gonna take aspirin and Motrin. Just in case. I mean, ibuprofen. You know what I'm talking about. I don't want no what's the names. Okay, juror select. Let's see what they say about these jurors. Were they biased? I mean, biased against Mr. Kelly based on what they heard. Let's see. Jury selection. Kelly argues that he was denied a fair and impartial trial, contending that after conducting voir dire, the district court impaneled 4 jurors who were biased against him. He also brings an ineffective assistance of counsel claim against trial counsel for the purported failure to conduct any meaningful voir dire of those jurors. Okay. Standard of review. Despite its importance, the adequacy of voir dire is not easily subject to appellate review. And then some case law. That is because the trial court, not unlike jurors later on in the trial, is best positioned to reach conclusions as to impartiality and credibility, by relying on its own evaluations of demeanor, evidence, and of responses to questions. Case law. Accordingly, the district court enjoys ample discretion in determining how best to conduct the voir dire and will not reverse unless we determine that the district court abused its discretion. There's a bunch of case law in here, y'all. Just in case y'all can see it. And I have to find out where the commas end and begin. It says, when a defendant raises a claim for ineffective assistance of counsel on direct appeal, we may, one, decline to hear the claim, permitting the appellant to raise the issue as part of a subsequent petition for writ of habeas corpus. Right? So that's the next phase between that or going to Supreme Court on this matter. 2, remand the claim to the district court for necessary fact-finding, or 3, decide that the claim on the record before us. Decide the claim on the record before us. And it's case law. And there's more case law. The Supreme Court has instructed that a habeas petition is the preferable vehicle for lodging an ineffective assistance claim, but that we may decide the claims on the merits on direct appeal when their resolution is beyond any doubt, or to do so would be in the interest of justice. Case law, applicable law, impartial jury. The Supreme Court has recognized that the voir dire process plays a critical function in assuring the criminal defendant that his Sixth Amendment right to an impartial jury will be honored. Case law. An impartial jury is one capable and willing to decide the case solely on the evidence before it. Case law. It says quoting McDonough, power equipment, and trying to accuse before a jury that is actually biased violates even the most minimal standards of due process. More case law. Although a district court enjoys broad discretion in conducting voir dire, it must, at a minimum, remove prospective jurors who will not be able, wait a minute, remove prospective jurors who would not be able impartially to follow the court's instructions and evaluate the evidence. Case law, bunch of case law. It says the defense deserves a full and fair opportunity to expose bias or prejudice on the part of the veteran. And some more case law. It says there must be sufficient fact-finding at voir dire to allow for facts probative of any of these forms of bias to reveal themselves. Otherwise, fundamental unfairness arises if voir dire is not adequate to identify unqualified jurors. Case law. Voir dire to be insufficient, for voir dire to be so insufficient as to call for reversal. The record viewed as a whole must show either 1. A voir dire so demonstrably brief and lacking in substance as to afford counsel too little information even to draw any conclusions about a potential juror's general outlook, experience, communication skills, intelligence, or lifestyle. 2. A failure to inquire about or warn against a systematic or pervasive bias, including one that may be short-lived but existent at the time of the trial. Or 3. A record viewed in its entirety suggesting a substantial possibility that a jury misunderstood its duty to weigh certain evidence fairly that would have been clarified by asking a requested voir dire question. 2. Ineffective assistance of counsel. To prevail on a claim of ineffective assistance of counsel, a defendant must show that 1. Counsel's performance was deficient because it fell below an objective standard of reasonableness, and 2. The deficient performance was prejudicial. Case law. For prejudice, a defendant must demonstrate there is a reasonable probability that but for counsel's unprofessional errors, the result of the proceeding would have been different. And remember, the Supreme Court has already established that for lawyers, you don't have to do an amazing job, any of that. You just have to do a would they say average or decent? It equates out to like okay. It's just right on the line. Application. So we have examined the record and conclude that none of the jurors whom Kelly challenges on appeal were improperly impaneled. For that reason, the resolution of Kelly's ineffective assistance of counsel claim is beyond any doubt, and resolving the claim on appeal is in the interest of justice. Kelly contends that jurors 3, 4, 5, and 12 cannot be fair and impartial toward him because of their personal knowledge of his case, their consumption of media about his alleged crimes, and their opinions on STDs. He claims it was reversible error for the district court to impanel them despite their answers to the written questionnaire and their responses during in-person voir dire. We are not persuaded. Oh. The district court conducted extensive voir dire, beginning with a questionnaire containing 108 questions that went to a pool of approximately 575 prospective jurors, and from which 251 were dismissed for cause based on their answers. Kelly's counsel then submitted the names of 145 additional prospective jurors who they challenged on his behalf. The government submitted a list of an additional 34. These individuals were excused prior to voir dire. The district court also directed the parties to submit any additional questions they wanted for in-person voir dire. The district court then conducted in-person voir dire of the approximately 145 remaining prospective jurors, a process that spanned 2 days. During in-person voir dire, the district court addressed the prospective jurors as a group and explained basic principles of law, including the presumption of innocence. The district court then questioned the prospective jurors individually, asking about their answers to the written questions and soliciting additional questions from the parties. Bearing in mind the district court's substantial discretion in conducting voir dire and the other principles articulated above, we find no reversible error here in the impaneling of jurors 3, 4, 5, and 12. The record indicates that each juror was subject to thorough questioning by the district judge before in-person voir dire. The district court determined, based on the questioning and after giving each side an opportunity to request further questioning, that each juror could be impartial when deciding the case. The following discussion with Juror 3 is reflective of the exchanges with all four jurors. In response to a question in the questionnaire asking prospective jurors if they had read, seen, or heard anything about the case, the alleged crimes, or people involved, Juror 3, prospective Juror 25 answered, I saw the documentary, but I forgot the name of it. The questionnaire also asked prospective jurors if they had read, seen, heard about Robert Kelly, also known as R. Kelly. Juror 3 marked the box for yes and wrote entertainer. I heard that he has been sleeping with underage girls. Finally, in response to another question, Juror 3 wrote, I saw a documentary about Kelly and his legal troubles. I don't know the full story, so I have no feelings about it. I remain impartial. During the during in-person voir dire, the district judge and juror three had the following exchange. The judge says, Mr. Kelly is presumed innocent, and it is the government that has the burden of proving his guilt beyond a reasonable doubt. If you are selected as a juror, I will explain what those terms mean in more detail, but is there any reason you can't follow that instruction? The prospective juror says, no reason at all. The judge says, is there any reason at all why you wouldn't be able to give both sides a fair trial? And the prospective juror said no. Following this exchange, defense counsel did not have any other request. Neither party exercised any challenges to excuse juror 3, who was seated on the jury. We agree with the district court that none of the challenges the defendant asserts on appeal would have warranted granting a challenge for cause. And again, a challenge for cause means that there's a reason that, you shouldn't be there. And a preemptive challenge is one they just give, and you get a certain number of those. It varies each state, and it varies for the government how many you get of each. It says the circumstances are nothing like Badir we found lacking in Neves, where the district court merely explained several foundational trial concepts and asked just 3 or 4 demographic questions during individualized Badir. We are satisfied that the district court here, through its lengthy questionnaire and 3-day in-person voir process, elicit more than sufficient information to permit Kelly to intelligently exercise his for-cause and preemptory challenges. That's the case law. The record also illustrates that all 4 now challenged jurors represented to the district court that they could be fair and impartial, follow the presumption of innocence, and hold the government to its burden of proof, and that anything they had heard or read about in the case would not impair their fairness. The trial court accepted these representations, and it did not abuse its discretion in doing so. So this particular challenge that Jabo made would have been against the judge. Okay, anything when it deals with discretion, that's judicial discretion, and um, that's the standard of review that they we use when looking at that. The standard of review that deals with judicial discretion. That's what I'm trying to say. I just can't get it out. Okay, so again, I know it was a lot of things. Well, people should have seen the thing, shouldn't have been on the jury, know about the case, know about our case, and I try to explain that. And once they say that they can be impartial, they're not going to be biased, and so on and so forth. And then they get hit with the subset of questions like the judge, did with this juror number 3 and what have you. I mean, that's it. And um, his his shit his lawyers didn't move to have them stricken for cause and all of that. And I think Jabo was right, because they didn't do that. That she hit them with the ineffective assistance of counsel challenge, but they're saying that they find that in this case that his attorneys that was present at that time made a pretty good decision with allowing those jurors to stay. So I'm pretty sure that can, you can still, y'all can still mount a good argument around that. All right. Kelly also cannot meet his burden of showing that counsel's performance was so deficient during voir that counsel was ineffective. The record shows that counsel performance did not fall below an objective standard of reasonableness. Indeed, trial counsel actively participated throughout voir. Counsel also, I'm sorry, y'all know I got thought in my head. I'm sorry. I got caught up in my mouth. Counsel made several successful per cause challenges over the government's objection. Oh shit. Okay. So when I tell you, they are really making sure they kind of put this to bed and it kind of stops here. You know, I mean, it's going to go beyond this, but I'm just saying, but that they really look at this when making the decision, because they're even pointing out that shit, the council, they were present enough, aware enough to make objections, make challenges, and shit over the government's objections and all of that. So they're saying that they were actively participating in the voir process with, making sure that they pick the right jurors and everything. And, they were saying, hey, his team is responsible and did a decent job with help picking the jurors that they got. They just closing the doors on like a lot of her stuff. Hmm. Okay. Defense counsel successfully persuaded the district court to dismiss a prospective juror who, as a supporter of the Me Too movement, stated that she believed that in most cases, women don't lie about allegations of sexual assault. Kelly therefore cannot meet the requirements of Strickland because he cannot show the counsel performed unreasonably during voir dire. And in Strickland, right, there are two prongs, right? And if the first one is met, then you go on to the second one. Okay. And Strickland is pretty much case of, so, and we went over that. Oh my God, back when J-Bo first came about. So we went over that. But Strickland has two prongs. So they're not going to go in all into it here or whatever, because they don't think y'all listening. They think this attorneys and shit is reading this. So, but when you see them throw out Strickland like that, they're talking about the test in Strickland, and it has two prongs. All right, it says the Rule 404B evidence. Kelly challenges several of the district court's evidentiary rulings, arguing that with virtually no limitation, the district court permitted the prosecution to inundate the jury with excessive bad act evidence, mostly under the theory that the evidence was relevant to the means and method of the enterprise. We considered the admissibility of four sets of evidence. One, evidence that Kelly exposed other women to herpes, offered to establish Kelly's knowledge of his diagnosis and to corroborate other testimony that it was his practice to have unprotected sex. Two, the testimony of an alleged victim of Kelly's uncharged conduct that she saw Kelly performing oral sex on Aaliyah, offered to prove Kelly's motive to obtain false identification for Aaliyah. Three, testimony from alleged victims of Kelly's uncharged conduct regarding his sexual contact with them, offered as evidence of the enterprise's means and methods. And 4, video recordings by Kelly of his sexual activity offered as evidence of Kelly's practice of recording sexual encounters as an evidence of the enterprise's means and methods. Standard of review. We review a district court's evidentiary rulings for abuse of discretion and will disturb an evidentiary ruling only where the decision to exclude evidence was manifestly erroneous. Case law, okay. To find such abuse of discretion, we must conclude that the trial judge's evidentiary rulings were arbitrary and irrational. Case law. Even if an evidentiary ruling is manifestly erroneous, we will affirm, and the defendant is not entitled to a new trial if the error was harmless. Case law. So I went through and I explained the different errors. You got plain errors, you got harmless error, reversible errors. That was when it's a harmless error. Um, it doesn't usually result in. Well, it doesn't usually. It doesn't result in any type of reversal of the judgment or anything like that. Sometimes it just may require correcting something administratively or something like that, or just go on record that there was an error. But other than that, okay, we accord great deference to a district court in ruling as to the relevancy and unfair prejudice of proffered evidence, mindful that it sees the witness, the parties, the jurors, and the attorneys, and is thus in a superior position to evaluate the likely impact of the evidence. Case law. When reviewing a district court's Rule 403 determination, we generally maximize the evidence probative value and minimize its prejudicial effect. Case law. Applicable law. 44B of the Federal Rules of Evidence governs the ability of other acts, crimes, wrongs, or acts other than those charged. FRE 44B. Evidence of other acts is not admissible if offered to prove a person's character in order to show that on a particular occasion the person acted in accordance with the character. 44B1. Such evidence may be admissible, however, if offered for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. Right, so, okay. Says the court takes an inclusionary approach to Rule 44B, under which all other evidence that does not serve the sole purpose of showing the defendant's bad character is admissible, subject to Rule 402 and Rule 403's respective relevance and prejudice considerations. Case law. Jesus, bunch of case law. You have the Second Circuit of 2012 explaining that evidence of uncharged criminal conduct that is inextricably intertwined with the evidence regarding the charged offense or necessary to complete the story of the crime on trial is not generally considered to be evidence of other acts governed by Rule 44B at all. Remember, she had an issue with the bad acts evidence being in there and saying that it could have been prejudicial. Here. dealing with character. Okay, it says to determine whether a district court properly admitted other act evidence, we consider whether one, it was offered for a proper purpose, two, it was relevant to a material issue in dispute, three, its probative value is substantially outweighed by its prejudicial effect, and four, the trial court gave an appropriate limiting instruction to the jury, if so requested by the defendant. Remember all those limited instructions that were given in the YSL trial? Yeah, same thing. Even if evidence is admissible under Rule 404B, it must still pass the balancing test set forth in Rule 403. This is what I was trying to explain. That when I start talking about these rules, this is the FRE part of it, right? And when I say the Federal Criminal Rules of Procedure, that's the FRCP part of it. Okay, there's case law. It says, in other words, the probative value must not be substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. And when we were talking about those text messages, and there was a ruling on them, a decision made on them by the judge, and they were citing 403 and all of that. This is what they were saying. Okay, that you can't use evidence that would be confusing the issue and misleading the jury. So if you put like text messages or something in there like that, that would suggest that the parents or anybody else out, other than um, well, you put some evidence in there that suggests that the parents had something to do with the crime, and knowing that that contradicts substantive law, for one, that's going to be could fall under 403. It's going to be confusing the issue and misleading the jury. Okay, and it also can be wasting time too. So, and the the um the prosecutors will object to that right away. I mean, a lawyer with good sense not going to even go there with that, because they already know. Okay, a trial attorney knows those little um knows the laws, the enumerated ones, but definitely the unenumerated ones, right? Especially when it comes to anybody underage. That's just it almost goes without saying. It's like you can't blame the underage person and the parents of the underage person on a crime that was committed by someone else, only in very, 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 very limited um limited matters, right? You just can't do that. And that's usually on the civil end of it, when it comes to civil crimes. But in criminal crimes, it's very rare. And I was surprised that she was going to let them mount a defense of extortion if they could have some evidence to support that, right? But it would have to have been clear evidence. And remember, she used the word direct, okay? So if you got direct evidence, that would be taking it out of the realm of 403, right? Pretty much so. It would be like, no, this is direct evidence, and it would play into reasonable doubt. Okay, but they could never come up with anything that would be evidence of extortion. Okay, let me keep going. Now, this was already ruled on. The judge. Now, if people don't understand how to read the paper, they ain't got nothing to do with me. I done showed it and played it and went over it and broke it down and broke it up and whatever. Put it 50,000 times. That's what it was. Okay. See application. To the extent that the evidence was inextricably intertwined with the evidence of the RICO conspiracy and the charged conduct, it falls outside the scope of Rule 404B. Even so, each challenged category of evidence would also be admissible under that rule, as we now explain. And also, if I'm not right, why she ain't introduced it? She had all the time in the world to introduce it. Hmm? Okay, because she love her license. So one, the evidence of herpes, Kelly first contends that the district court abused its discretion when it admitted massive amounts of evidence that Kelly exposed others to herpes and transmitted it to them. We disagree. Well, let me read that over again. Kelly first contends that the district court abused its discretion when it admitted massive amounts of evidence, okay, that Kelly exposed others to herpes and transmitted it to them. We disagree. Oh, okay. It was neither arbitrary nor irrational for the district court to admit evidence that Kelly transmitted herpes to others. Kelly argues that the evidence was excessive and unduly prejudicial, considering Dr. McGrath's unequivocal testimony that Kelly was diagnosed with and receiving treatment for herpes. But as the government points out, and the district court noted, evidence that Kelly transmitted herpes to several other women, one of whom told Kelly that she had contracted the disease, and another of whom was with Kelly in his home when she received her diagnosis, was directly probative of Kelly's knowledge of his diagnosis, which the government was required to establish to prove Racketeering Acts 8, 12, and 14, as well as counts 6 through 9. This evidence was relevant and probative, especially because defense counsel did not stipulate that Kelly knew he had herpes. Ooh, baby. Now they doing the prosecutors. I don't say they're doing the prosecutor's job, but what they're saying is that because the defense did not say agree that he had herpes, the prosecutors had to put in this evidence. Oh, they trying to box you in, child. They're trying to box him in, honey. Woo! They saying like because you ain't go ahead and say you had it, you gonna complain now about the evidence they had to use to prove it? Hey, dirty game, child. Okay, the use of this evidence falls squarely within Rule 404B proper purposes. Furthermore, we cannot say that the district court abused its discretion in balancing the probative value and prejudice of this evidence, especially considering that Kelly put his knowledge of his herpes diagnosis at issue and the government was entitled to refute that assertion. Mm. 2. Angela's testimony about Aaliyah. We also conclude that the district court did not abuse its discretion when it allowed Angela to testify about seeing Kelly perform oral sex on Aaliyah. This testimony was admissible because it was probative of Kelly's motive to bribe local officials to fabricate identification for Aaliyah, Racketeering Act 1. The testimony was especially relevant to establish that Kelly and Aaliyah had a sexual relationship in the first place, given defense counsel's refusal to concede that fact. The probative, wait a minute, okay, had a sexual relationship in the first place, given defense counsel refusal to concede that fact. Okay. Oh, so they're saying that, okay, here again, they're saying the same thing. Since You didn't, since you didn't go ahead and admit to it, we had to put the evidence in. Ooh, they boxing them in. Dang. The probative value of Angela's testimony was not substantially outweighed by unfair prejudice to Kelly because the testimony about Kelly's sexual relationship with Aaliyah was not more inflammatory than the charged crime. Okay. And there's more case law. And that's just pretty much saying. So let me give you a prime example. Anybody that watched the YSL, do y'all remember that point um, where Love had what was 10 pieces of evidence to something about pictures showing that they were like just to prove that they were in a game, like the flag, the colors, the this, the that, and whatever, right? So um probably that's a little, that's a little excessive. That is that's a lot, right? And they were saying like, why you can't use like one or two pieces to prove that, right? So in this case, right, um, when Angela testified that she seen, you know, what she saw or whatever, that evidence, it wasn't, um, it wasn't too much. What I'm saying is, it was just another single piece of evidence to prove count one with regards to Leah, right? So it wasn't more inflammatory, as they're saying here, than the charged crime. It was just another piece of evidence. Okay. But they're saying, if he could have conceded to this, and I think that's kind of unfair because, it's a defendant's right if they want to concede or not. So, but they really trying to, uh, they really trying to make sure that they're saying, hey, you had an opportunity to stipulate to this and you didn't, so they had to use whatever evidence to prove their case, and they didn't find that it was overwhelming, that it was prejudicial, it was too, so I see what they're doing. All right, other victim testimony. We are also unpersuaded by Kelly's argument that the testimony of other witnesses, Addie, Alexis, Kate, Anna, Angela, Lewis, and Alex, was cumulative and unduly prejudicial because none of the listed individuals were associated with any of the charges. Now, come on now, this is weak. This is weak. They don't have to be associated with any of the charges because, and that's what, scratch that. They know that they don't have to be associated with any of the other charges, if in order for it to be considered cumulative, because and it came in as bad acts. They're trying to say like, I mean, if that's the case, if you're going to say that, then you might as well say that you there's not a time for you to introduce bad acts evidence. Like, what are you talking about? I don't agree with that. I'm gonna keep reading it, but I don't agree with that. Okay, unless there's some kind of rule somewhere, because there's always a rule on a rule on a rule where um no, it can't be because she wouldn't have even went at that if there was a rule that says that just because the additional evidence um associated with people as uncharged acts can't be considered as a violation of what 403 because it wasn't associated with any charges. Like, come on now. Okay, it says the district court acted with this discretion when it admitted the testimony. The testimony of the witnesses, who were also minors at the time their abusive relationship with Kelly began, is evidence that Kelly's behavior towards the charged victims were part of a pattern. Oh, okay. So you want to You want to say it's relevant because it's not violating 403 because it's showing as part of a pattern. Okay, I see what you're trying to do. That's what you're trying to do. So there's some case law. It says to demonstrate pattern of racketeering, it is not the number of predicates proved, but rather the relationship that they bear to each other or to some external organizing principle that indicates whether they manifest the continuity required to prove a pattern. Baby, when I tell you, and I'm sorry for all this commentary, but I'm just thinking out loud. First of all, uh, they really don't want him out because they went ahead because we've already discussed the RICO portion of this. Okay, they went ahead and tried to justify all that bad acts evidence to saying that it shows a pattern also of a pattern of racketeering, which is the RICO portion of it, right? Racketeering acts and shit. So they're trying to justify having all of that bad acts evidence submitted in that, they looking out for their judge, I guess. I don't know. Wow. Hmm. It is well settled that in prosecutions for racketeering offenses, the government may introduce evidence of uncharged offenses to establish the evidence of the criminal enterprise. Again, we've already went over RICO earlier. Why are you trying to attach the bad acts evidence? That's what we're dealing with to a RICO in this particular area of this document. We've already discussed that. Damn. Mm. Damn, boy. Oh, a case law. Let me go. Okay. Where the existence of a racketeering enterprise is at issue, evidence of uncharged crimes committed by members of that enterprise, including evidence of uncharged crimes committed by the defendants themselves, is admissible to prove an essential element of the RICO crimes charge. The existence of a criminal enterprise in which the defendants participated. Indeed, the admissibility of such evidence is not governed by Rule 44B at all because it is direct evidence of the charged conduct. Likewise, we have noted that the evidence beyond a defendant's own predicate acts, whether alleged or not, is relevant to establishing a charged pattern of racketeering. Case law. Therefore, we do not hesitate to conclude that the government may introduce evidence of uncharged conduct to establish a pattern of racketeering activity, and the admissibility of such evidence is not governed by Rule 404. Okay. Okay, wait a minute. Hold on, y'all. Wait a minute. I got to do this. Okay, that's page 72. Y'all just bear with me. You know how we do. We be in the interest of fairness. Okay, is this about 404 evidence? Okay. Okay. I mean, I'm not going to. I'm just saying. I understand what they're saying is true based on how they interpret it or whatever. Okay. I'm just saying that we're back now talking about RICO in this area, which they can, but I just think that they've already made their argument as to why that the bad acts evidence was, you know, was did not. I mean, the judge did not abuse her discretion by allowing it to go on and talk about how you can qualify it because it proves, proves the RICO and the pattern of racketeering activity. Well, now you transport me back to the part that I was reading in the beginning about the RICO. I guess this white people business. This ain't got shit to do with me. Let's keep reading. This white people and rich people problem. This ain't got shit to do with me. I guess. Um. Okay. With respect to Kelly's Rule 403 challenge, none of the testimony was more inflammatory than the charged acts. As a result, we cannot say that the district court abused its discretion in admitting the testimony of other victims. But what you're supposed to be dealing with abusing her discretion her, her discretion when it comes to the admission of this bad acts evidence. I'm gonna figure out why they bringing Rico into it. I'm gonna come up with some type of administrative reason because okay. Anyway, y'all got me questioning good old white folks. I would never done that if I hadn't been assembled amongst you niggers. I don't do that. Boy, I'm questioning my people. Hey, boy, is it the video evidence? Finally, three of the government's exhibits were videos that Kelly made of his sexual encounters with multiple victims. One, a recording of Kelly directing two victims to engage in oral sex. Two, a recording of Kelly spanking a victim who was crying and robotically calling herself a slut and stupid. And three, a recording of a victim covering her naked body in feces. Oh. Kelly argues that these videos were unfairly prejudicial and not probative. The videos, however, were properly admitted to show the means and methods of the enterprise, including the level of control and dominance Kelly had over his victim. This video demonstrates Kelly demanding absolute commitment and not tolerating dissent, and creating embarrassing and degrading videos of sexual partners to maintain control over them, which were charged which were charged means and methods of the RICO enterprise. I can understand what they're doing now. The feces video corroborated Jane's testimony that Kelly similarly directed her to eat feces as punishment, which is relevant to Kelly's level of control over Jane and whether he coerced her to travel to have sex with him in violation of the Mann Act. Okay. They are saying that all this evidence was necessary to establish the RICO. I was thinking more or less that the argument on the floor was that the evidence was um, just prejudicial to him because it was too much, right? And that's and it seemed like the argument was about that. But if I'm not mistaken, between Bonjean and with the government at all phases when she took over all the way through to her oral argument. It seems like the appellate, the appeals court is kind of doing the job for them, kind of in a way, because they're saying, well, yeah, this evidence was submitted to prove the RICO, which is, see, I don't know if you could speak. I don't know if it was just used to. Eventually, it substantiates the RICO by the pattern of racketeering activity and the predicates and all of that. But I thought the arguments, if I'm not mistaken, I thought the arguments was just, it just prejudiced him because it was, it was too much evidence that that influenced the outcome of his trial. And I don't remember. I may be wrong, but I don't remember the prosecution making an argument that all that evidence was proof of the RICO. I thought that all that evidence, they used it as proof of the, just to substantiate his pattern of that, this is what he would do. This is just to support the charged acts. When I'm talking about the other ones, not the count one, but two, and that's what I thought, but I may be wrong. All right, it says the district court did not abuse its discretion in admitting this evidence. And I'm honest, and we don't read a lot of this stuff. I don't remember the judge addressing it that way when it came to this. Now y'all know I'm gonna go back and pull it. I don't remember the judge addressing that evidence this way. That it supported count one. The bad acts evidence. I don't remember that. I may be wrong. Okay, now we get to the monetary awards, restitution. Kelly challenges the district court's award of restitution of two victims and its directive to the BOP to seize funds in his inmate trust account. He does so on three grounds. One, the government failed to prove that James and Stephanie's herpes diagnoses were attributable to him. Two, the government failed to prove that Jane or Stephanie required a suppressive rather than an ad hoc or occasional herpes treatment regimen. And three, the government failed to prove that Jane or Stephanie required name brand Valtrex over generic and less expensive, was it Valclover? Valclover? After the initial hearing, the government requested restitution as relevant to this appeal. One, $357,000, $357,218.18 per Jane, pursuant to 18 U.S.C. Section 2429 and Section 3663 for genital herpes and related medical expenses, therapy costs, and loss of income, and $78,981.72 to Stephanie, pursuant to 18 U.S.C. Section 3663 for genital herpes, related medical expenses, and therapy costs. Kelly opposed the government's request. At the restitution hearing, the district court imposed $300,668.18 in restitution for Jane and $281,168.18 for herpes treatment and $19,500 for three and 3/4 years of therapy and $8,200 for Stephanie's past therapy expenses. The district court concluded that Kelly owed Stephanie restitution for her herpes-related medical expenses, but deferred decision on the amount subject to further clarification from the government as to whether Stephanie was treating her herpes with Valtrex or Valacloriver or whatever, the generic, less expensive version of the drug. On October 5th, 2022, the government submitted revised calculations for Stephanie, seeking 40 $45,587.20 in restitution for Stephanie's herpes treatment expenses. In an order dated November 8th, 2022, the district court imposed $70,581.72 in restitution for Stephanie for her herpes treatment and $8,400 as compensation for past therapy costs. Standard of review. Our review of district court's restitution order is deferential, and we will reverse only for abuse of discretion. Questions of law raised by challenges to restitution orders are reviewed de novo, while factual questions are reviewed for clear error. The applicable law. Federal courts have no inherent power to order restitution. A sentencing court's power to order restitution therefore depends upon and is necessarily circumscribed by statute. There are two restitution statutes relevant to this appeal: 18 U.S.C. Section 2429 and 18 U.S.C. Section 3663. Section 2429 is the mandatory restitution provision for Mann Act violations. A court shall order restitutions to victims of Mann Act offenses in the full amount of the victim's losses. And 18 U.S.C. Section 2429 AB1. Victim means the individual harmed as a result of a crime under this chapter. And Section 2429D. The full amount of the victim's losses is defined as including. And also, y'all, I have a judge wrote his independent opinion, so I got to read that too after I read this about this money. So let's see if we're going to find something in there. So don't haul that shit. So we're going to make sure we see if we can find something in there. Let's see. Any cost incurred or that are reasonably projected to be incurred in the future by the victim as a proximate result of the offenses involving the victim, including A, medical services relating to physical, psychiatric, or psychological care, B, physical and occupational therapy or rehabilitation, C, necessary transportation, temporary housing and child care expenses, D, lost income, E, reasonable attorney's fees, as well as other costs incurred, and F, any other relevant losses incurred by the victim. Section 3663 is the Victim and Witness Protection Act and permits a sentencing court to order that the defendant make restitution to any victim of an offense under Title 18, Section 3663A1A. Under that statute, restitution is not mandatory, but the purpose of Section 3663 is to require restitution whenever possible. A victim is a person directly and proximately harmed as a result of the commission of an offense for which restitution may be ordered, including in the case of an offense that involved as an element a scheme, conspiracy, or pattern of criminal activity, any person directly harmed by the defendant, criminal conduct in the course of the scheme, conspiracy, or pattern. 18 U.S.C. Section 3663A2. Under Section 3663, a court may require a defendant to A, pay an amount equal to the cost of the necessary medical and related professional services, and devices relating to physical, psychiatric, and psychological care, including non-medical care and treatment rendered in accordance with a method of healing recognized by the law of the place of treatment. B. Pay the amount equal to the cost of the necessary physical and occupational therapy and rehabilitation. And C. Reimburse the necessary income for loss by such victim as a result of such offense. The government bears the burden of proving the amount of restitution sought, and any dispute as to the proper amount or type of restitution shall be resolved by the court by the preponderance of the evidence. And while we require restitution awards to be tied to the victim's actual provable loss, the amounts of restitution need only reflect a reasonable approximation of losses supported by a sound methodology, sorry, methodology, sorry, case law. 3. Application. A. Kelly contends that the district court abused its discretion in ordering restitution as to Jane because, in his view, the government did not meet its burden of establishing that 1. Jane was infected with herpes as a result of the charged conduct. 2. Jane is being treated with suppressive regimen of Valtrex. And 3. Jane will actually treat her herpes with Valtrex rather than the cheaper generic Valaxclavir, whatever it is. We disagree. Oh. First, we find that the government meets its burden of proving that Jane was infected with the herpes as a result of the charged conduct, specifically his violation of the Mann Act as to Jane. The district court did not abuse its discretion, determining that Kelly's Mann Act conduct was sufficiently connected to Jane's harm. Jane testified that she contracted herpes when she was 17 and during her relationship with Kelly. She also told Kelly that she had been intimate with only him. From this evidence and the ample evidence that Kelly had herpes, we cannot say that the district court's conclusion that Jane is a victim entitled to mandatory restitution rests on a clearly erroneous view of the facts or on a legal error. So, meaning an error in which they can reverse the decision. Turning to Kelly's second and third objections, we also conclude that the district court acted within its discretion in ordering Jane restitution in an amount to cover a suppressive regimen of Valtrex. While we agree that restitution for losses must be grounded in some reasonable approximation and not mere conjecture or speculation, case law, we decline Kelly's invitation to undo the experienced district judge's careful rulings after briefing and a thorough restitution hearing. We agree that the government proved proved the victim's loss by a preponderance of the evidence and given the broad remedial measures of the restitution statute, the district court reasonably ordered a suppressive regimen to keep Jane in an outbreak-free state to the extent possible. And remember, you keep hearing preponderance of evidence because the standard is different here now, okay? The standard is different. It's not um, by beyond reasonable doubt. It's by preponderance of the evidence because this is a different matter. It's involving money. It's more like civil, like something civil. says, okay, we are also satisfied that the district court acted within its discretion in ordering restitution based on cost of a name brand rather than a generic drug. Covering Jane's cost for a name brand drug does not give her a windfall. Here, Jane would not have had to purchase herpes medication if Kelly had not infected her with the virus. Oh, 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 yeah. And like the district court, we are not aware of any authority requiring the victim to pursue the cheapest option to minimize a defendant's restitution expenses. Moreover, the record indicates that both Jane and Kelly were being treated with Valtrex at the time. Yeah. Stephanie. As to Stephanie, Kelly argues that there is no evidence that Stephanie contracted herpes from Kelly because his medical records confirmed that he tested negative for herpes in June 2000, and Stephanie claims that she contracted herpes in 1999. He also argues that the district court abused its discretion by inflating the amount of restitution that it awarded her. We agree that Stephanie presents a closer question because of the timing of her herpes diagnosis. And based on our review of the record and the trial transcripts below, we note that Stephanie did not testify about herpes at trial. The evidence of her infection comes from materials submitted for sentencing. Oh! We nevertheless conclude that the district court did not abuse its discretion in determining that the government meet its burden of proving that Stephanie was a victim by a preponderance of the evidence. At trial, Dr. McGrath testified that herpes tests can yield false negative and that Kelly's June 2000 test was not conclusive. And in light of Stephanie's testimony that she had a sexual relationship with Kelly when she was 17 years old for about 6 months, and her prior statements that she was not having sexual relationship with anyone else at the time, we are satisfied that the government has met its burden in this respect. Our analysis as to Kelly's challenge to the amount of restitution awarded Stephanie mirrors our analysis as to Jane. The district court's order of restitution was based on the government's reasonable approximation of Stephanie's losses. We therefore affirm the district court's restitution order in all respects. Seizure of funds. On August 4, 2022, the BOP seized approximately $27,000 from Kelly's inmate trust account upon the direction of the government. The government then sought an order from the district court directing the BOP to turn over the seized money to the clerk of courts for deposit in an interest-bearing account pending a restitution determination. The district court granted the order. Kelly challenges this, arguing that the district court lacked authority to authorize the turnover because Kelly was not in default on any fines and was not provided with any notice of default. He contends that there is no authority for the proposition that the government may restrain his property preemptively for the use against a future restitution award that has yet to be entered. He also argues that the government acted prematurely and without legal authority when it ordered the BOP to seize his monies from his trust account, absent any showing that he defaulted. Applicable law. Under the Mandatory Witness Restitution Act, MVRA, a judgment imposing a fine may be enforced against all parties or rights to property of the person fined. 18 U.S.C. Section 3613A. A fine assessment or restitution order imposed under certain statutes act as a lien in favor of the government on all property and rights to property of the defendant. Section 3613C. Under the MVRA, if a person obligated to provide restitution or pay a fine receives a substantial resources from any source during the period of incarceration, such person shall be required to apply the value of such resources to any restitution or fine still owed. The MVRA expressly states that criminal restitution orders may be enforced against all property or rights to property, making quite clear that absent an express exemption, all of a defendant's property are subject to a restitution order. Okay, that's the case law. It's Second Circuit 2022. Citation, oh, never mind. No, case law. Application. As explained above, a judgment imposing a fine or restitution is a lien on all property and rights to property of the person fined. 18 U.S.C. Section 3613C. While Kelly makes much of the fact that his BOP funds were seized before an order of restitution was entered, he ignores that the government sought these funds either to satisfy Kelly's restitution judgment, which was yet to be imposed, or to satisfy the court-ordered fine, which had already been imposed. Indeed, the district court had already ordered a $100,000 fine, $900 special assessment, and $40,000 assessment under the Justice for Victims of Trafficking Act, which well exceeded the approximately $27,000 in Kelly's BOP account. Because Kelly's BOP funds are not exempt from seizure under 18 U.S.C. Section 3613A, the district court acted within its direct discretion in ordering Kelly's BOP funds be seized to pay outstanding restitution and fines. We see no error here. Conclusion. We have considered all the arguments presented by Kelly on appeal and concluded they are without merit. For the reasons set forth above, we affirm the district court's judgment. Okay. So we had a judge that did his own thing. He did his big one. But he did his big one in the chat. He wrote his own paperwork. Okay, well, we need to see if this judge, we can get something out this judge. Let me see how many pages. Ain't that many pages? All right. Judge Richards J. Sullivan says, okay, concurring in part and dissenting in part. I join the majority excellent opinion with respect to nearly all of the defendant Robert Sylvester Kelly's challenges on appeal. I write separately only to address what is, in my view, the district court's error in calculating victim Jane restitution award. Okay, come on with the money. Come on through. Let's see what we get. I agree with the majority that the government met its burden of proving that Jane was infected with herpes as well as, hold on, y'all know I get excited. Jane was infected with herpes as a result of the charged conduct, and that the district court was within its discretion to award Jane restitution for a suppressive regime, of herpes medication. Nevertheless, I believe that the district court abused its discretion in calculating Jane's restitution based on a lifetime supply of the brand name drug Valtrex rather than the significantly cheaper generic drug Valacloric, or however you pronounce it. Accordingly, I would remand for the district court to either make additional findings or modify the restitution award. Before the district court, Kelly argued that the government inflated the cost of Jane's herpes medication by requesting restitution based on the cost of Valtrex rather than generic drugs. Specifically, Kelly noted that the generic Valtrex, how to pronounce that, cost on average $15.31 for a 30-day supply, resulting in a total lifetime expenditure of $9,829.02. Valtrex, by comparison, costs $421.29 for a 30-day supply and $270,000, $270,466.18 over the course of Jane's lifetime. In response to these objections, the district court simply noted that Jane would not have had to spend money on herpes medication had a defendant not infected her with incurable disease when she was 17 years old, and that a victim is not required to pursue the cheapest option to minimize a defendant's restitution expenses. While both of these observations are correct, our case law requires a district court to do more in crafting a restitution award. Specifically, a district court must ensure that the award is a reasonable approximation of losses. Case law. With respect to restitution awards for future medical expenses, we have explained that a district court's estimate of those expenses must be made with some reasonable certainty. Case law. Here, nothing in the record suggests a qualitative difference between Qualitative difference between Valtrex and the generic drug, or that Jane used Valtrex exclusively. As a result, I do not think that the district court could say with reasonable certainty that Jane could purchase Valtrex rather than the generic drug for the rest of her life, nor could the district court say the restitution award of $270,466.18 was a reasonable approximation of Jane's future medical expenses. This is especially true considering that the district court calculated the restitution award for another victim, Stephanie, using an estimate price for the generic herpes medication, which was only $35.74 per month. The district court provided no explanation for treating Jane differently from Stephanie. Oh boy. Oh, they got you, Donnelly, on something. Furthermore, we have previously held that a district court abuses its discretion when a restitution award provides a windfall to the victim. Case law. While it is true, of course, that Jane would not have had to purchase herpes medication had Kelly not infected her, there is still a concern that the district court's restitution award will provide Jane with impermissible windfall. Jane could use the restitution award to purchase the generic Valacor, whatever, and then pocket the substantial difference of over $405 per month, which amounts to more than $260,000 over the course of a lifetime. For all those reasons, I believe that the district court abused its discretion in calculating Jane's restitution award based on a lifetime supply of the brand name of Valtrex rather than generic drug Valcor, whatever. I therefore respectfully dissent from this portion of the majority opinion and would vacate the district court's restitution award as to Jane and remand for further proceedings. The district court would then be free to either make additional findings on whether awarding whether awarding the cost of Valtrex was reasonable approximation of Jane's losses or to modify Jane's restitution award. In all other respects, I join the majority of opinion. Mm. Hold on, y'all. All right, sorry about that. I got head is hurting. So what y'all think? Y'all think? Anybody still out? What y'all think, child? And, um, only thing different with the Hague is that you just get to argue other points that wasn't raised in court, right? Stuff that wasn't on the record. Still have to follow the law though. You know, still have to follow that damn law. So, turn you down. Them 800 Motrin. Oh my God, ibuprofen. They so big. I'm trying. Oh, oh, dick child. Mm. So you can't tell me I don't. Oh, I don't call non-traditional because you gonna be like, go here, Hopper, let me come see it. I don't want her wading through my hair until it's time to check to see if I have open. I just don't be wanting to bother people all the time and stuff. And I don't want to go out. Um, I don't want to go to the doctor. Definitely don't want to go to the ER room. I'm just thinking if I take these ibuprofen and it's asthma, you know, maybe I won't have an issue. What y'all think? I know what I can't add right now that I don't think I'm gonna get a chance to deal with tomorrow is that damn. Did y'all see that Wendy Williams doc child on Tubi? Ooh, yeah, maybe because I took notes. So I don't know. I don't know. I would do it on him now. I don't know. I'm gonna have time. And I wanna listen. Let me add Wendy Williams on this. TV. Y'all, baby. That Tim, listen, that Tubi, tell me, you keep messing around with that Tubi, you've been on South Pen a whole day and had it on Tubi. Cause it was another movie that and them movies done got better. The one that says I married a baller, I spent no money there. Mm-hmm. Let me look at something real quick. Ugh. So, I mean, he got a little break with the money, with the money. Man. Has he already paid that to her? Like what's going on with that? Has he already paid that to the Django number 5? Oh, I'll be mad as hell. Oh, I'll be cussing that damn judge out. You done messed up my $270,000 extra. And I got to do adding. Somebody got to do some adding and subtraction and shit. I mean, wait a minute. He did the figures. Wasn't it 270,000, and he knocked it down to 9 over a lifetime, 9, like a little under $10,000, baby. I have to meet him up to the mall. It's going down. uh baby. That right there ain't right. You messing up the money. Oh, I know she like what? Anyway, y'all listen. I don't know if y'all seen it yet, but Wendy Williams on that Tubi child and the TMZ and now I took notes. I want to make sure I don't miss nothing. First of all, Wendy Williams is up there dressed up like she is on the Single Ladies video with Beyonce, baby. And I passed out because if y'all know, did y'all know she was up there holding the Wendy Williams little question and answer cards? Huh? The little cue card. Y'all seen that? And they were talking about, she sounds good. She reminds them of the old Wendy and all this, that, and third, whatever. Yeah, because that is due, in my opinion, all this is my opinion, that's due to her restrictive living. Okay? If she was not being held like she is, and being monitored and being restricted access to this and all of that, she'd be looking and acting like she was in that damn the other documentary. So I don't hear none of that. Like she didn't get. See, here's the thing, right? She didn't get that way, get to where she is now, because she did it herself, right? She was out on her own. She stopped drinking. She went to whatever. It wasn't something that she volunteered to do herself. They had to make her do whatever, change her lifestyle, her living, and that's what it produced. So I don't know if that's what they will point out, and when she goes to court or whatever. I don't know. So, but I know that they had to make her change her ways. Okay, and again, I don't know why her, what this fine print, um, what's the reason that she has to have such tight controls, like what was put on there, but it had to be pretty, pretty convincing to the court. I mean, must be some stuff going on that we're not aware of, and because Wendy is in her manipulating ways and things of that, she's not gonna tell us what give us the full detail that it was going on. But I'm surprised we got as much detail as we got, especially about her beloved Kevin child. But I'm getting there. Um, so for some reason I wrote down the judge. Oh, they're saying that the judge is to permit Wendy as much independence as practical. All right, that was the judge's order. That was the judge's order to the guardian. Okay, well, now that's where now that's going to be a he say she say type situation because the guardian, if it's the guardian that set those regulations and those controls in there and everything, then the guardian is going to have some type of proof and evidence that Wendy should be held under those conditions. Wendy's going to have her proof and evidence that she should not. Because it seems like the judge left the controls and if TMZ is reading the latest orders, with regards to her care, okay, what is supposed to be allowed and not allowed, what is supposed to be controlled by the guardian, then the judge kind of the judge says to permit Wendy as much independence as practical. Um, so I don't know. So then they had this lady on there that's supposed to be a professional in that field. She said she's been there for 30 years. Okay. I swear, 30 years, this must be the shit to say. 30 years. And when I was listening to the professional, she was giving an assessment as far as rehabilitation assessment, meaning like, okay, from where she encountered her, where Wendy started to where she is now, she's improved. All right. She's not giving a risk assessment, meaning, okay, if she don't do this, she don't take a medicine, if she does all of that, then this is what can happen. If she's not in this type of environment versus that kind of environment, this can happen. She's not giving a risk assessment, she's giving her rehabilitation assessment. All right. She's not assessing why the improvement. She's just assessing the fact that has improved. Like what caused, the improvement? Like, you know, she's not doing that. There's a difference. Um, oh yeah, they are complaining, oh my gosh, about the downgrade of the life, and it's so small and the people so old, and I only got this and I only have this and whatever. We don't know if that is all her money can afford. We don't know if that is the best place that will fit her needs. You understand what I'm saying? Because if she has specific needs, then the place that you're placed in have to have, you know um, have to be able to, you know able to make sure that they can. Um, shit, I'm acting like I got that shit now. Make sure that they can. Damn, I'm drawing blanks. Ooh, shit, maybe I should go out to the damn hospital. But comply with what she needs, you know. But that's just crazy. Let me see. Oh, I also wrote down here that I believe that they are manipulating us on all fronts, right? So, and seeing that's if she gets, I don't know what type of assessment is she going to get out, other than the um, the doctor like testing her for that dementia, aphasia, and stuff again. She needs to also sit down with one of them, psychiatrists or psychologists, someone that can assess her emotional behavior and all of that. Because I'm trying to tell you, she's manipulating the hell out of us. Okay, she's up there talking about claims of retaliation, emotional abuse, and all of that. Talking about it's like being in jail, the sympathy, how she can turn on and off the crying at the drop of a dime. She's in that window, like, save me, oh Lord, save me. I mean, it is terrible. I mean, it is terrible. It is terrible. Oh, let me get to my other parts before I get to the cabins, child. Oh yeah, and when she was out, right, in the documentary, because she was showing the excerpts from the documentary. Remember, she was out, and she was like, "Well, why can't I drink alcohol, and why can't I do this? Why can't I see that type of attitude? Uh 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 uh. See, well, that niece don't understand whatever. Okay, yeah, that's what you don't understand why y'all not addressing why she's in is as in damn. I got that shit. I know my lips are spelling, but god damn, why she is in good as shape as she is now, based on what opposed to what we saw before. Address that. You need to do that assessment. Don't just do that. Yeah, she seems to be rehabilitated. Get to why. Like, let me see. Oh, they were saying that when Wendy did the documentary, she was under the care of the guardian. So they were saying the guardian, is pretty much essentially is responsible for the shape she was in then, right? That she was, that she did the documentary and out riding all around arguing at people about weed and shit. And I just acting like a damn fool. Y'all seen that documentary, right? And they're saying that they believe that based on the fact that she did do that documentary and that the guardian overreacted to what she saw. That's why she got her all locked up as she does now, with very little um, wiggle room. So, let me see, what is this? Let me see. It says she wasn't in her right mind because I can't make out my own hair right now. Yeah, but I want to get that goddamn kid. Man, beloved Kevin child. Mm, 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 mm. So, baby, now we up here while we thinking that Kevin was looking out for Wendy, taking care of Wendy, and all this shit, whatever. That ain't what they said, especially the mama. This is what the mama said. She loved herself some Kevin, baby. Let me tell you. She said Kevin Jr. was making unauthorized charges and shit. She said this is exactly what she said, and the bank came in. She said, thank God. So she said no more um stealing for Kevin Jr. and his friends that was helping him. Yeah, that's what she said about Kevin Jr. I'm like, oh yeah. hmm Yes, she said. She said that it was her son along with his friends that was doing that. She even said that it was some lady that pretended to be her that went to the bank and stuff that was getting the money. Child, they was running a scam. And said they met the lady. She said she met the lady through Kevin Jr. Yes. Said it was Kevin Jr.'s friend. Oh, yeah. I couldn't believe it. I could not believe it. Not Kevin Jr. hmm And this right here took me all the way out. Said that he went to the bank and is supposed to be getting a boat for $1,500. So well, it turned out to be $113,000. And he said that the bank wanted him to have that boat. Hmm? Now she said she didn't understand that. Nobody else didn't understand that. How the boat that's supposed to be a rental for 1,500, why did it turn into $113,000? Now it seemed like for that amount he was trying to buy it. Yeah, because and I don't know what kind of boat he was trying to rent for 1,500 though. Let me tell how much the boat rentals is in New York, New York area. Hold on. Depending on what kind of boat you get to. Let me see. Okay, so that's about right. That's about right. And it depends on like so he must be trying to buy that boat. He must be was trying to buy that boat, honey. Because if you get like for 1,500, that's a good size rental, and it's a nice boat, but it depends on what kind of boat you're trying to rent. And you got to be careful with all that too. Mm-mm. So I don't know, honey. I do not know where to go with this. I know that girl like the hell. You gonna mess up my damn money? Ain't nobody told you to pull out your calculator. Oh, DB, you said you made onion dip. Yeah, that was hours ago. I'm just not reading it. Mm, well, it's finally in. That part did Von Jean ain't didn't put that on Twitter? Hold on. Cause she usually tell us when the stuff come in. Let me see. Mm, that's right. Why they took my notifications? Elon. I don't see. That's crazy though. But I'd be mad as hell. They done come in there and mess with my a whole 200 something. Huh? Oh, stay out my business. Woo, stay out my business. Ooh, look, it came right on in here. I'm sitting up here, ain't that jack came right on up in my I guess I could have read this hours ago. They said, didn't such and such, no. I, I'm like, did you hear them? Yeah. I'm like, okay. Let me go see. Mm, mm. Yeah, I appreciate. Thank you, Purple. Purple, thank you, Queen Bree. Yeah, I sure enough do appreciate it. Mm. Well, all right, y'all. Let me get on out of here, babe. I gotta go figure out. I gotta stop eating damn BLTs, girl. Gotta stop doing that. This sinister, honey. All right, y'all. Hey, I sure appreciate y'all. Sorry about the choppy read. Hopefully, y'all got the understanding. And as per usual, make sure you do something good for yourself and someone else. Make today a good day. Make tomorrow an even better day. And I am out of here on pages of reading. I ain't even put on the automated read. I ain't think about that till it was too late. I could have been back and eating bacon sandwiches and all. Anyway, I appreciate you. Hey, and I'm out of here. And so are you.